The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court. The first case is 20-21-25, Redeemed Christian Church of God, Bowie, Maryland, versus Prince George's County, Maryland.
Mr. Ray?
Thank you, Judge King. Good afternoon, Your Honors, and may it please the court.
Good to have you with us, sir.
Thank you. The principal question presented in this appeal is whether or not a legislative amendment to a county water and sewer plan constitutes a land use regulation subject to the Religious Use and Institutionalized Persons Statute, the acronym RLUIPA. In this case, appellee purchased 4 parcels of land in order to build and develop a 60,000 square foot church with impervious parking surfaces to accommodate a minimum of 750 vehicles for the parking lot. The property that was purchased was in a Category 5 under the county water and sewer plan, which is reserved for future low-density residential development. It's basically well and septic. In order to proceed with the development, the applicant here, the church, had to apply for a legislative amendment to the water and sewer plan under Section 6.3 of that plan in order to upgrade the property to Category 4 and obtain public water and sewer. The process by which that amendment is decided is a legislative process. It is subject to criteria set forth in Section 2.1.4 of the plan. It is decided during one of 3 legislative sessions by a vote of the county council after public hearings and comment. Among the criteria that the county council is mandated by both the Maryland state law and the plan to consider are traffic, safety, and infrastructure in the community that surrounds this property and the burden on the local taxpayers. The county followed.
And how can the traffic issues be considered when appellant didn't provide any evidence of traffic issues or any traffic study?
Appellant, they can be considered, and the plan at the county council level does not require a traffic study of any kind. And the evidence that was presented was by 21 witnesses at the public hearing.
And that's the evidence that you presented to the district court as well? That's the only evidence?
That is correct, in addition to photographs that accompanied the testimony, which were not presented at the county council, but were admitted into evidence before.
Did you call the people at the trial, or did you just put in the evidence or testimony when they showed up for the meeting?
Both. We called 4 individuals who testified before both the Bowie City Council and the County Council at trial, and we admitted the entire record of the application and the public testimony below.
Yeah, it seemed to me that Judge Chasno gave you a really good shot at it by giving you a 3-day trial.
She did.
To prove your contentions, and she knows what she's doing.
I have
respect. You had full discovery, right? You had all kinds of discovery.
We did.
Y'all worked this case pretty strong. And got a 3-day trial.
We did.
I guess that makes her opinion is sort of like a specific verdict that normally don't get from a finder of fact. She wrote it all up, findings of fact and conclusions of law. That puts you in a position to have an uphill battle.
She did have findings of fact and conclusions of law. I would respectfully suggest that the fundamental question was answered incorrectly by the trial court, and that is whether or not this amendment constitutes a land use regulation or the application of a land use regulation.
Counsel, before you go to that, going back to Judge Thacker's question, you mentioned the 21 people. Can you tell me what you believe the best evidence that you put forward to meet your burden that this particular church would negatively impact the traffic? Who am I looking? I mean, I understand you're saying they're 21, but we're not general. I'm not looking for general traffic problems, but who had the knowledge and expertise to be able to say that the addition of this church would negatively impact traffic?
Yes. I believe the individuals who testified had that knowledge and ability, and the evidence that was put forward was, one, this development was going to accommodate a minimum of 750 vehicles at discrete points in time, going in and going out from events and church services. Two, the roads at issue are old and in disrepair, and we presented evidence of significant accidents on those roads adjacent to the property, at least a dozen of them, all of which resulted in personal injuries, many of which resulted in helicopters having to medevac people out. Those were also submitted in the photographs. We also...
I'm sorry, but I think, and certainly Judge Richardson can correct me if I'm wrong, but I think Judge Richardson was asking, which of those 21, and maybe there's more than one, witness, do you think provides the strongest evidence in support of your argument?
If that's what you're asking, I would say that Ms. Sims is one. The woman who escapes my memory right now, who testified about the events on Sundays, is the second one. She talked about sporting events and the families that go there right next to this property.
So speaking of the sporting events, why aren't the sporting events the problem? With all these kids going back and forth across what is allegedly a dangerous highway, why would the church be the problem? It's not even there yet. How would denying the church ameliorate the traffic problems that are already there? Sounds like these kids running around at the soccer games might be more of a challenge.
And they very well may be, but the question is not whether or not the church caused this problem. The question is whether or not it will exacerbate it. And
how do we know whether it will exacerbate the problem? Does Ms. Sims, is she an expert of some sort?
No. And we could not do a traffic study. This trial, the entire trial and all discovery was expedited at plaintiff's request. Our side consented to that. And it occurred.
So you could have gone out and you could have gone somewhere and hired an expert on the traffic and got him to explain why you couldn't widen the road or put up traffic lights and things of that nature. That's the way traffic's usually controlled.
We could have done that, yes.
If you've got much traffic, you do something to handle it. I mean, does the county council, that's what you represent?
Yes, well, the county, Your Honor, yes.
Does it have the responsibility for handling the traffic problems when they occur?
It has a responsibility for addressing traffic problems.
Well, and they got an office that happens to deal with that kind of stuff. You could have called those witnesses to explain why they couldn't do anything to accommodate the church if they build a church there. A little bit more traffic on Sunday.
It is possible, but that also was not our burden, Your Honor. If what you're alluding to is that there are other less restrictive means, that was never presented by the plaintiff or the applicant, and it is their burden to establish that there are less restrictive means. And the county, yes.
Counsel, can I go back to the question that I asked? I say you Ms. Sims and the events on Sundays. As I understand their testimony, and I'm sure you're more familiar with it than I am, they talk about how bad the traffic situation is today and has been for some time, right? but neither of them have lay or expert knowledge about what impact a church would have on traffic.
Neither of them have expert knowledge.
Or lay knowledge. I mean, do any of them have any experience with the impact of a church or other facility on traffic patterns?
Two of them did testify that we travel these. In answer to your question, no. If the specific question is, did they have lay knowledge of the impact of a new development in this area? No. But they did.
So but that's what I'm trying to get at, right? So I guess what you're telling me is that your position is that you can meet your burden merely by having individuals say traffic is bad, full stop. So as long as you can say traffic is bad, then the judge below was required to conclude that it must by necessity going to get worse for reasons that you didn't put in the evidence. Is that, I mean, I'm not sure I'm even following your argument, to be frank.
That is not my argument, Your Honor. My argument is that the individuals here understood the traffic, understood, and common sense allows them under the law to understand what the effect of 750 more cars in discrete timeframes will have on that traffic. That does not require expert testimony under the law, and one can draw a very reasonable inference based on that testimony that introducing that many vehicles into this confined area at confined times would exacerbate the problem. That is our argument.
I just want, but that's it. You don't have evidence to that effect. Your point, as I take it, is that we need to assume that as common sense, that a fortiori it must be that the traffic safety problems, there'll be greater numbers of wrecks and all these conclusions you want us to draw comes from the existence of the facility with nothing more.
Not the existence of the facility, and it wouldn't matter what the facility is, whether it's commercial, retail, or church. That's the issue of LUPA, is it's discriminatory towards a church. It's the issue of introducing 750 to 1,000 additional vehicles to an already dangerous situation. I think it is a reasonable inference, and the law says that when you have situations of traffic, you can draw that reasonable inference that it would be exacerbated.
Has the county ever conducted a traffic study before in this area?
It did not.
Before this?
Before. There's nothing in the record that indicates they did before the trial.
Or ever even considered conducting a traffic study in this area before this church issue?
I don't know. I do know, actually, I know that there was an assessment of the roads done. I don't know if that included a traffic study. It was not among the record.
Who did this assessment? The county?
The county did for appropriations to do $10 million in improvements to widen the roads and put shoulders on them to make them safer. And that was.
And was that done?
No, they don't yet have the funding for it. That was one of the stakeholder issues that the county council addressed in saying that the applicant could reapply. I would also.
Did y'all put?
I'm sorry.
Is that in evidence? You put all that in evidence?
It is in evidence, John.
Okay, and you could have asked for a jury trial here too, could you? Y'all had a bench trial.
Of course, yes, we could have.
That's right. You waived your right to a bench trial, and the judge found against you. She, on page, I noticed on her opinion, page 21 of her opinion, she even said, and I quote her, "This is not a close call," unquote.
I understand. On the evidentiary issues, that was her opinion.
What makes it look like she didn't think much of your case, my friend. You were sitting up there.
All right. I respect your opinion, Your Honor, in that respect. If I could, just a few final points because my time is running short. I don't believe that RLUIPA applied to this decision at all in the first instance because RLUIPA requires an individualized assessment of the proposed use. There was no individualized assessment of the proposed use in this case. It had nothing to do, the water and sewer plan and the amendment to that plan is completely indifferent as to the use. If it does not entail an individualized assessment of the proposed use, it is not governed by RLUIPA. And that purpose
If this case isn't governed by RLUIPA, are you challenging our jurisdiction to hear it at all?
I think it is a subject matter jurisdiction issue, and I did mention that in my brief, that there is not jurisdiction. It's not.
And you say state law applies and not federal law, right?
I do, and the reason I do,
and you presented that to Judge Chasnon, and she shot that down too.
She shot all of our arguments down. Correct, Your Honor. She did.
I mean, you have a jurisdictional claim that you preserved, but then Judge Chasnon rejected it. She said it's federal statute that's governed by federal law, and if she's wrong on that, then you'd be perhaps entitled to some relief here. But that's she ruled against you on that, and then ruled against you on.
She did
on the rest.
And I'd like to answer your question, but I am cutting into my rebuttal time. Is it all right, Your Honor?
You go right ahead. Yes, sir. Go ahead.
Thank you. While the court below focused on the individualized assessment and said that this was an individualized assessment, there was very little analysis in her opinion about the second component of that phrase, which is necessary, of a proposed use. There is nothing in this record that shows that the use of this facility as a religious organization versus a commercial versus a residential versus anything was at all a basis of the decision. In the first instance, RLUIPA does not apply unless it is a land use regulation or application of that regulation, whereby you make an individualized assessment of the proposed use. That's zoning. Zoning discusses the proposed uses. This is not a zoning, and the structure of the statute supports this. The Maryland Environmental Article, Title IX, mandates the creation and amendments of water and sewer plans. The Maryland Land Use Article mandates Montgomery County and Prince George's County in Title 27 to enact zoning regulations. They are two separate bodies of law. And while there may be protection issues or some other issues, an amendment that is legislative to a water and sewer plan is not, the plan is in the record and the testimony. You can read the plan. Nowhere in there is the use, and nowhere in the record of the county council's decision is the use of the property as a religious organization the issue. And that's the fundamental purpose of RLUIPA as narrowed from RFRA. I will reserve my last 2.5 minutes. Thank you, Your Honors.
Thank you, Mr. Ray. Ms. Casey, you out there?
Yes, good afternoon, Your Honors. And may it please the court. Despite Prince George's County's yes, Your Honor. Despite Prince George's County's arguments to the contrary, RLUIPA plainly applies to the county's decision to deny Victory Temple's water sewer category change. In fact, this case presents exactly the circumstances that RLUIPA was adopted to protect against. Specifically, Victory Temple, a minority religious denomination, sought to build a church large enough to accommodate its growing congregation. Victory Temple complied with all applicable land use regulations, and Prince George's County's subject matter experts all agreed that the church should proceed with its development plans. However, after hearing from dissatisfied community members who expressed opposition towards the church, the county stopped Victory Temple's development in its tracks, citing a plethora of vague reasons on the record, like traffic impacts, environmental impacts, potential pollution, and inconsistency with the area master plan. For purposes of this litigation, the county has winnowed that plethora of reasons to one: traffic safety. After a 3-day bench trial, Judge Chasnow
Traffic safety is listed as one of the criteria to be considered for evaluation in the water and sewer plan, isn't it? And how is that not at least an appropriate consideration?
Your Honor, it's not that traffic safety is an inappropriate consideration. The issue is whether at this stage traffic safety represents the county's decision to based on traffic safety is the least restrictive means of furthering a compelling governmental interest. So it's not that traffic safety can't be considered, it's whether solely basing the decision on traffic safety can satisfy strict scrutiny. And Judge Chazanow found that the county couldn't in this case. And that finding is entitled to deference. It's reviewed on a clear error standard. In fact, Judge Chazanow didn't simply find that the county failed to meet strict scrutiny, she found they wholly failed to meet strict scrutiny, that the basis of the decision in traffic safety was untethered to the decision to deny the water sewer category upgrade. So the county first argues.
Counsel, can you go back to where your colleague ended? And I take his argument, maybe not fairly, but because it has to be an individualized assessment of a proposed use, that the statute only applies if the stated reason for a county's denial is like the type of building and not the extension of government service like sewer. Respond to that argument for us.
Certainly, Your Honor. First, I think it's important to look at the text of RLUIPA itself, which says that the statute applies when a county or local government implements a land use regulation or system of land use regulations that permit the government to make, or when the government does make, individualized assessments of the proposed uses for the property involved. Before I talk about those specific language, Your Honor, I want to mention that that Congress has directed, has inserted a specific canon of construction into the statute that requires courts to interpret.
I know the canon, but what I'm trying to get at is, I take your colleague's argument to say that's limited to uses of land, not the provision of government services, right? And so the sewer is the provision of government service, not the use of the land. If they denied it on the grounds that it's a church, all right, the statute applies because that's the use of the land. If they deny it based on the type of government service that they're going to provide, then I take his argument to be that's not a land use regulation, that's a government service extension. And so the statute simply doesn't apply.
Your Honor, perhaps that may be true if that's all the water and sewer plan did, but it doesn't in this case. The water and sewer plan permits the county, in fact, directs the county to consider a whole range of development and site-specific criteria that are, in fact, related to zoning issues. Things like, for example, whether the proposal will affect environmental quality, what the traffic impacts might be, and other various things. And so in this case, the county did make an assessment, individualized assessment based on the proposed use of the property. Whether it was assessing based on its use as a church is insignificant for this evaluation. It's the fact that the county assessed that the property was going to be used to build a 60,000 square foot structure with parking spaces for up to 750 vehicles. In fact, Chair Todd Turner, when he, in his remarks at the April 23rd, 2019 TIEE meeting, explained his reasons for moving to deny Victory Temple's application, that's specifically what he referred to. He referred to testimony from public citizens about the size of the building, about the size of the parking lot.
I just want to go back to his point. I just want to make sure I understand your argument here. Because I take his argument to be is that the county did not deny the temple any use. All it said was, we're not going to provide this government service to you. So if you want to build, if you come back and say, I want to build a 60,000 square foot temple with all these parking spaces, but I'm going to use septic system and I'm going to drill a well, so I need neither water nor sewer, I take his position to be that is a government service issue and not a land use issue that they've denied you on. They denied the government service, not that they've denied your land use. I'm not sure I fully understand what your response to that is.
Yes, Your Honor. Let me try to explain. The water sewer plan, in making a decision under the water sewer plan to deny a reclassification of the property from category 5, future community service, to category 4, that does more than just deny the property owner access to public water and sewer service. In fact, it's a barrier to further development of the property. And the record makes that clear. In fact, it's very clear in the record, the water sewer plan itself states explicitly that a property cannot move forward in the development review process while it is in category 5. And to your Honor's question about septic, there's never been any position advanced by the county that the church could move forward and build on septic. And there's evidence in the record, testimony from Barry Cason, who was an engineer at Ben Dyer, which conducted the feasibility study that the church had done in this case, that if a property owner wants to build a property greater than 5,000 square feet, it must move to category 4. And there's no way, Your Honor, that a structure less than 5,000 square feet could accommodate Victory Temple. Victory Temple was looking to build a church of 1,200 to 2,000 seats. Its current church is 521 seats, and it has 2,000 members. So 5,000 square feet is not an option. It needs to move to category 4 to be able to build a bigger structure. And that's what the county prevented it from doing.
Do you agree if the situation was different? I understand this is a hypothetical, but if the county said, instead of what happened here, we'll move you to any category you want to be in, but we refuse to provide you water and sewer. So you can do anything you want to on your land, but you will never get water and sewer from us. Would that fall within the statute?
Yes, Your Honor, because it would be a substantial burden. It would be a substantial burden on Victory Temple's religious exercise, because without water and sewer.
Substantial burdens only matter for land use regulations. My point would be that's not a land use regulation. That's a government service denial. I'm denying you service. You can use your land however you choose. I'm just not sending you sewer.
Well, Your Honor, if the county's unwillingness to provide sewer meant that the property owner couldn't build a structure of the size that would alleviate a substantial burden in this case, then it would be a land use regulation under RLUIPA. So, Your Honor, in any event, the way that the plan is constructed, it is part of a larger system of land use regulations in Prince George's County. It's a core function of the development process in the county to get a water sewer upgrade from category 5 to category 4, then proceed into the development review process, at which all of the things that the county purportedly was concerned about in this case, specifically traffic impacts and road safety, can be addressed. Judge Thacker asked why the county hadn't, or whether the county had previously gotten a traffic study in this case, in this area. In fact, if the county had done what least restrictive means require it to do and advanced the property to category 4, that's when a traffic study would, in the ordinary course, be performed. That's when the county's experts, subject matter experts, the MNC-PPC could weigh in and ask the county to, ask Victory Temple to undertake traffic studies, archaeological studies, grading studies, assess stormwater management, all the things that typically occur in a development process. The county didn't let Victory Temple get to that stage because by keeping the county and keeping the property in category 5, Victory Temple couldn't move forward. And I want to just
one of the lawyers. Were you one of the lawyers at the trial?
Yes, Your Honor.
Was there a discussion of why no expert witnesses were offered or testified?
The county didn't, my recollection, Your Honor, is that the county didn't put forward an expert at trial and didn't explain why it hadn't had one. Of course, the county said in its brief it's because of COVID that it wasn't possible to get a traffic study, or a traffic study wouldn't have been helpful. But I think even more importantly, Your Honor, there was no traffic study done during the administrative process. So the county didn't have that evidence available to it when it was making a decision purportedly based on traffic safety. The only evidence the county had before it during the administrative process when it was considering Victory Temple's application was the anecdotal commentary and observations of neighbors who lived in the area. The photos that Mr. Ray mentioned, as he acknowledged, were not put forward before the county council. The evidence that, other evidence they've put forward in this record of compilations of police reports, also those were created post hoc for purposes of trial and were not put forward before the county council. So to the extent that an expert study even would have been admissible before Judge Chazanow because it wasn't admitted before the county council, certainly the county council didn't have that information available to it. Your Honor,
did they try to reopen the case or anything after the judge ruled to get in more traffic expert witnesses or anything?
No, they did not, Your Honor. They did not. Your Honor, I'd like to talk about what evidence is in the record that shows that the county's decision was not based on traffic in this case, was based on something other than traffic. And before I do, I'd just like to point out what the standard is here. Strict scrutiny is an exacting standard, as the 10th Circuit put forward in Yellow Bear versus Lampert, which is at 741 F 3rd 48, cited in our brief. RLUIPA's compelling interest test is a strict one. Congress borrowed its language from First Amendment cases, applying perhaps the strictest form of judicial scrutiny owed to American law. That test isn't traditionally the sort of thing that can be satisfied by the government's bare say-so. So in this case, what is the evidence that the county employed the least restrictive means of furthering a compelling government interest? It can't be a broad general interest. It must be specific, and that's the test that Judge Gorsuch articulates in his concurrence in Mass versus Fillmore County. The question is not whether the county has a compelling interest in traffic safety generally, but whether it has such an interest in denying Victory Temple's water sewer category reclassification specifically. And as I mentioned earlier, the record is replete with evidence that something other than traffic safety motivated the county's decision in this case. Beginning with Chair Turner's remarks at the April 23rd hearing, he articulated a series of what he called compelling reasons, which this can be found at page 743 of the joint appendix. And I quote, he said, are including but not limited to traffic impacts, the environmental impacts, the economic impacts, the fiscal impact, potential pollution and air pollution, lack of infrastructure, including for stormwater management, potential impact on the quality of life, inconsistency with the general and area master plans, no demonstration of a hardship by this applicant, and additionally, the city of Bowie's position. In addition, this court can look at the comments in opposition made against the church by community members at the April 16th the April 16th County Council hearing. Those speakers were not, as the county has asserted, united in a concern about traffic safety. In fact, their comments were wide-ranging, including concerns about potential light pollution, exhaust from parishioners' cars, and most notably, a potential decline in property value. That came up quite a lot during the April 16th hearing. And there's also evidence in this record that earlier in the application process, before negative comments were made about the church, county stakeholders had no concerns.
And why did they think that the addition of a church would cause a decline in their property values? What was their purported reason for that?
Your Honor, I can only surmise from their comments, but based on the comments at that hearing and the comments in the No Mega Church petition, which is in the administrative record and was before the county council, they argued that mega churches were, and I quote, hulking parasitic entities or tax evaders or bloated castles. And so I can only surmise, but I have the sense that the neighboring community members had nice homes and single family lots and believed that the addition of a church of this size would detract from their property values. But to Your Honor's point, there was no evidence of that. It wasn't as though a property assessor came in and gave testimony about that. These were just the speculations of neighbors. Your Honor, as I was saying,
wouldn't that be characterized as lay evidence?
I don't even know if it qualifies as lay evidence, Your Honor. I think it's more akin to speculation.
Okay.
Again, the county itself had no concerns about traffic before these disgruntled community members spoke at the hearing. When the representatives of Victory Temple met with Chair Turner himself in February 2019, they showed him a conceptual site plan of the 60,000 square foot two-story church. And according to testimony of Art Horn, an attorney for Victory Temple who was present at that meeting, Chair Turner was fine with the proposal and had no issues with it. The MNC PPC also met with representatives of Victory Temple before Victory Temple submitted its application. And minutes from that meeting, which are at pages 1691 to 92 of the joint appendix, reflect their thought that the transportation section doesn't believe there are any significant traffic concerns because the intersection was recently improved. That's subject matter experts from the Maryland National Capital Park and Planning Commission. Also,
now, what was the date of that opinion in relation to all this?
So those minutes, that meeting was conducted, I believe it was.
I'm talking about, you read something about no traffic concerns.
Yes, yes, Your Honor. That meeting was held, I believe, May 18th, 2018. But it can be, the notes can be found at 1691 to 92 of the joint appendix.
Now you would agree that traffic concerns are legitimate concerns for something like this?
I agree that traffic concerns could be legitimate concerns, that there's a world in which they could satisfy strict scrutiny, but the county hasn't mounted evidence to meet its burden in this case.
I understand, but traffic concerns could be the basis for something. I mean, they got to be safe, right? The intersection's got to be safe. It's got to be safe for.
Certainly, Your Honor. Judge Chazanow concluded without deciding.
Safe to come to church and leave.
Your Honor, Judge Chazanow, if I understood you correctly, Judge Chazanow concluded without deciding that traffic safety likely would constitute a compelling government interest. And although we cite cases in our brief that have concluded the opposite, but again, whether traffic safety is an interest as a general matter is a different question than whether it could be specifically a compelling government interest sufficient to base the decision in this case.
You all are not against traffic safety, and neither are we. So we're not going to get hung up on that. Whether
no, Your Honor. No, we have no. We agree that traffic safety is important.
They didn't prove it here. That's your position.
That's correct, Your Honor. Yes, that's correct. That's what Judge Chazanow found, and her findings are reviewed only for clear error. Your Honor, I just want to add, Your Honor, that this whole litany of excuses that Victory Temple that are in this record, the record of testimony and exhibits containing negative statements about Victory Temple have been winnowed down by the county to just the one excuse that they think the court will believe: traffic safety. But the county's shifting justifications for its denial decision smacks of pretext and undermines its argument that traffic safety constitutes a compelling government interest in this case. Your Honors, I see that my time has expired. We certainly request that you affirm the order of the district court entering a permanent injunction against the county in this case. And unless Your Honors have any other questions, we'll rest on our briefs.
Thank you, Ms. Casey.
Thank you, Your Honor.
Mr. Ray? Mr. Ray, you reserve some time.
You're
Mr.
muted.
Ray, if you could unmute yourself, please.
We got it. Sorry. I'd like to address the last point that my colleague stated, that these reasons smack of pretext. In essence, what is being argued here is that there was a discriminatory intent or animus or against this church by the county council that drove this decision. A few important points here. Number one, the only claim that was brought in this case was pursuant to subsection A of RLUIPA. That is the substantial burden test. Subsection B of RLUIPA addresses discriminatory animus, intent, and pretext. No claim was brought under that. Number two.
So your point is the fact that you showed animus to the church doesn't matter here.
No. My point is there was no animus shown by the county council to the church, and that comes to my second point. The county, the overwhelming evidence that has been suggested here was a petition that was part of the record, never addressed by the county council, never discussed or analyzed by the county council. Not a single county council member addressed anything concerning a megachurch. The county council's decision was based on the traffic concerns as well as other reasons. Whether or not we winnowed down to what we considered the most compelling reason or not is not the point. The overwhelming testimony, if you read it from the record before the county council, concerned traffic, not property values that was made an illusory comment to. And yes, it's speculation on both sides, but traffic accidents, property, and these are traffic accidents right next to this property, not in the broad county. So that record is.
And are you saying that the reason the county didn't do a traffic study to submit into evidence to support their overwhelming issue was because of the pandemic?
We couldn't do a traffic study. And I can't get into issues outside the record, Your Honor, but that was one of the most significant reasons. A traffic study requires traffic, ordinary course traffic. All schools were closed.
And yet, but I thought that in your opening portion, you said that the county consented to the expedited trial.
It did. That's correct.
Well, then it's sort of a problem created in your own by your consent to the expedited trial.
Yes and no, Your Honor. I mean, no one in this circumstance then could predict this pandemic or the effects it would have. Before discovery even began, before this people stepped off the platform at the train station, we consented to plaintiff's request for an expedited trial. So I think that you're right. We did consent, and ultimately that was an issue. But I don't think that can be equated to all of the ramifications of this global pandemic that affected this trial, and knowing those at the outset. The last thing I would like to address with my remaining moments is the idea that it wasn't until the community testified at the county's public hearing that all of a sudden it became traffic. That is inaccurate. There was an earlier public hearing before Bowie, and it is in the record, and Bowie's recommendation, which is specific about the improvements needed to the road, the traffic issues this development represents, and just those issues is in that document, which is in this record. Moreover, the Transportation and Infrastructure Committee met on these very issues and recommended to deny the application. The final thing I would like to say is, while there is not a traffic study in this record, it was not discussed at trial. It was not brought up one way or the other at trial. And there is no requirement in the water and sewer plan or under the law concerning these types of issues that a traffic impact study or expert testimony be required for this. I thank you, Your Honors. I ask you to reverse the decision below. If there are no other questions.
Thank you very much, Mr. Ray.
Thank you.
The case will be submitted. Madam Clerk, you can call the next case, if you will, please.
Argument in the next case, 2021-85, Canaan versus Montgomery County, Maryland.
Good afternoon, Your Honors. May it please the court, I'd like to get straight into what I believe is at the heart of this appeal, and that is the question of reasonable expectations. Under this court's precedents, RLUIPA, substantial burdens provision, has been interpreted to provide a claim under certain circumstances. Number one, Would it serve an unmet religious need? Number two, was the denial absolute? Number three, which I think really added here, whose fault was this decision? Was it the church or religious organization at issue going where they're not allowed, or was it the government's fault for denying when it had to be that it would be out? The land use regulations here, I believe, are clear. First of all, nobody disagrees that the use is permitted on this property by right. That's not an issue. What is at issue are the question of these master plans, two different master plans that work together that further regulate the use on this property. The Burtonsville Neighborhood Crossing Plan, which I'll just refer to as the BCNP, is the local master plan. Again, nobody disagrees that it recommends against sewer access for this particular property. But it says another thing
Council,
as well.
can I just ask you, you used the phrase there, words matter here, that it recommends against. I read it as barring sewer. And so help me understand why instead of barring sewer, you think it should just be read to be a recommendation or suggestion.
Sure. Well, there's two answers to that, Your Honor. Number one is master plan. It's not a law. Now, under Maryland law, master plans do have the force of law. Their recommendations have the force of law under certain circumstances, such as this. But the other, and that's why I'm technically referring to it as a recommendation instead of having being a regulation or a law itself. The second, I believe, more important answer is what the BCNP also does, and it also says that that access to sewer services, that it supports the use of sewer service, public sewer service, consistent with the service policies in the county's main comprehensive water supply and sewerage systems plan, which I'll just refer to as the water and sewer plan. So it says no sewer to this area, but it also says we support the service policies in the water and sewer plan. And that's where we get to the heart again of this matter. The water and sewer plan says that if you're a PIF and you're outside of the sewer envelope, because you're a PIF, because you're a nonprofit institution, you get a certain benefit. And that benefit is if you meet these specific objective criteria, you get access to sewer. And that is clear from the text. There's no limitation on that provision, neither the water and sewer plan or the BCNP. And importantly, that's exactly how the county has interpreted that provision through other applications in the past, including in the year or two before the Canaan application. The court has granted sewer access to other applicants because they were PIFs, notwithstanding specific recommendations in the local management plan that say no sewer service to that property. Now, the county has, there's another critical point here, Your Honors. The county has—
Go back and just make sure that I'm following. In the BCNP, you say that, on I believe you're paying on page 709, that it supports the use of sewer service consistent with the water and sewer plan. But that's immediately followed by saying the plan recommends against providing public sewer for rural edge properties under any circumstance, right? So why wouldn't we think of that just being that the specific obviously governs the general?
Because I believe that one is addressing the specific service policies, one is addressing specific conditions where the properties are located. The way to resolve if there is conflict, if they are somewhat inconsistent, is how has the state interpreted those provisions in the past? And the way they have reconciled those provisions is by understanding that if you're a PIF, you get the benefit of the service policy, even if there are specific recommendations like that in the local master plan. The MDE, after consultation with the Maryland Department of Planning, has looked at two other applications, the Shreemangle application and the Glenstone application cited in our materials, where there were similarly specific recommendations against approval, and said that the requests were consistent with the master plans and the PIF policy. The county has repeatedly referred to this MDE, saying that the state wouldn't allow approval of this, when the state itself has said that in similar circumstances, it doesn't have a problem with that. It finds it consistent to be with those plans. The other reason why this any perceived inconsistency interpretation is the county's own. If you have a general recommendation in a local master plan against a sewer access, that can be overcome by the PIF policy, but a specific recommendation cannot. And there's absolutely no basis for such distinction. There's nothing in the text. The county has never applied it that way prior to the Canaan application. And the county's own witnesses say that that's basically based on their appeal. They could point to no written documents. They could point to no law or regulation that supports that interpretation. So read together.
I'm not totally sure I'm following that. So I get the museum story, different plan, different set of circumstances, but I'm looking at the particular plan that we had, the BCNP plan, and it says, yes, this supports the use of sewer consistent with the plan, but no sewer under any circumstance for rural edge properties, right? And what I don't see is any analogous master plan that specifically identifies the very property you're asking about and says, oh, absolutely not there. That then turns around and is allowed.
And I would refer Your Honor to, again, we discussed the Glenstone Museum, where there is a specific recommendation saying that access,
wasn't that a different master plan?
It was a different master plan, but it's not the master plan that is at issue here. It is the denial of the application under the PIF policy, which the county has
what if we think you look at the master plan, not this PIF policy, which is merely a part of the master plan?
Your Honor, that we have two different claims where this is implicated. The first being our substantial burdens claim, and that goes to the reasonable expectation. And the question is, would an applicant in their position reasonably expect that given the county's practices with respect to other plans,
Well, what about the fact that the church's own real estate agent said that Tom Norris keeps insisting that we will have no regulation issues getting water and sewer. I so far have gotten different information from the county. That's what the church's own real estate agent said. So how could there be a reasonable expectation otherwise?
Well, there's two issues there, Your Honor. First is, if the county is telling them one thing that is contrary to their own regulations, then I don't think a RLUIPA claimant can be said to not have a claim under the substantial burden provision just because the county said something wrong to a potential applicant. The second is, if the county, even assuming that the county didn't want this church or didn't want this property being developed, and I'm not talking about a non-discrimination claim here, but if there was some sort of hostility towards a particular property owner or a particular property being developed for whatever reason, that seems to fly in the face of the purposes of RLUIPA, which are to protect these kinds of uses, protect against hostility, and to be read broadly according to its rules of construction. With respect, and I want to answer the rest, finish my answer with respect to the other master plan. With respect to our equal terms claim, we used the Glenstone Museum as a similarly situated comparator, and the issue there is not, the court has not had an equal terms case yet, but looking at other circuits look at what they call either the regulatory purpose or the regulatory criteria at issue. courts have looked where you have an as-applied type challenge where there's a denial. What is the reason for the denial? And the reason for the denial here was not this plan is different from that plan. The reason for the denial was there was a specific recommendation against sewer service for this particular property. And with the Glenstone property, that's exactly the case as well. It said, we specifically exclude properties adjacent to and in the vicinity of the lower Greenbrier branch properties. That is a specific targeting of specific property in that master plan, similar to the reference to the rural edge properties in the first and that the county understood it. The county understood that that plan, that the Potomac plan recommended against approval and had a specific recommendation against approval there, but it was still granted. And when it went up to the MDE actually reversed part of it. They said, well, you can't have sewer access.
Weren't all the contracts for this property contingent on this very issue?
Yes, they absolutely were. And this is another
all
issue
right, so then can you deal with our opinion in Andon, which says that where the parties knowingly entered into a contingent lease agreement for a non-conforming property, their burdens are self-imposed hardships?
Well, that would set up, Your Honor, I don't believe that that speaks to a reasonable expectation. Either the laws allow the use or they don't allow the use. Entering into, to say that a plaintiff must take the risk and not enter into a contingency provision, which is just common sense, or else he might lose any.
Are you saying that Andon was incorrect or just that it doesn't apply here?
I'm saying that the holding of Andon was that the use was not permitted on the property there. The property did not meet the specific criteria for a church in Andon, and the plaintiff should have known that and did know that beforehand, and so they had no reasonable expectation, as opposed to this case where the specific regulations at issue do permit the use. That's the distinction between our case and Andon.
Well, except for the part of the regulations that Judge Richardson has read a couple times.
And again, the way that, if there is any inconsistency, the way that that has been resolved by the county itself and by the state, by Maryland Department of Planning, by MDE, is to read them together and to acknowledge that a PIF use does get the benefit, even if there is a specific recommendation against sewer access to that specific property. Looking at it in the abstract is also a little beside the point. The question is, would an applicant at the time of buying the property, submitting the application, knowing, I guess, what a reasonable property owner would know, and seeing that the county has interpreted in this way in the past, and seeing the text of the provision, believe, or at least reasonably believe, that they could have access to sewer in those circumstances. And I think that there's no question here that they would, regardless of what county officials might have told a realtor or what one of the property owners might be saying in an attempt to sell the property. The regulations are still what they are.
Before you finish here, I want to know what you want us to do with this case. What do you want us to do? What's the result you want on each claim?
Your Honor, I believe that the district court's decision should be reversed on our equal terms claim, that there is no question that we are entitled to relief under that. And I think at that point, at least the liability question of that claim is over. Alternatively, because the court did not rule on the...
By reverse, then you say it's over. You want a trial?
Well, we
or do you want summary judgment in your name? What do you want?
I believe we were entitled to a summary judgment on that claim.
So you want the summary judgment that you lost vacated, and then you want a summary judgment award in your behalf. Is that correct?
With respect to the our equal terms claim under RLUIPA, yes, Your Honor.
That's correct. You want summary judgment. You don't want a trial. You want summary judgment. Okay.
Oh, With respect, I'm sorry, Your Honor, my time is over. May I finish responding?
I still want you to tell me what you want. Go ahead.
With respect to our RLUIPA substantial burdens claim and free exercise claim, because there has been no ruling on the compelling governmental interest, least restrictive means questions, we believe that vacating the district court's opinion and remanding for further proceedings would be appropriate.
What would these further proceedings consist of that you want?
Well, I believe that it would either be a further briefing on the compelling interest, strict scrutiny analysis, or a trial on those issues. I think that the district court would have to make it.
And you want the district court to decide what to do then? You don't have a specific request?
Well, we believe that there are no genuine issues of material fact, as we argued down below. The district court did not make any decisions on those aspects of our claims based on its decision on the other elements. So we believe that we were entitled to summary judgment on those issues.
Okay, is that all you have to say on that? Anything else, Judge
Yes.
Thacker, Richardson?
No, sir.
No.
Let's see if you ever say some time, sir. We'll hear from Mr. Feldman.
Thank you, Judge King. May it please the court, my name is Howard Feldman and I represent the appellees, Montgomery County, Maryland, Montgomery County Council, and former county executive of Maryland. There's a lot to unpack, and I'm a big believer that context is everything. And so I want to give some context to the claims, and then I'm going to address head-on points that Mr. Storzer discussed regarding BCNP and Glenstone and his plaintiffs' appellants' equal terms. It's important to understand here that this case is here today as a result of the plaintiffs' effort to manufacture a claim for nearly a decade. After years and years of unsuccessful efforts to develop their properties for mostly secular purposes, 10 years ago, the landowners embarked on a campaign while the BCNP was still being drafted and considered by the county council. They wanted to upzone their properties to permit development, high density townhouses, and determined ahead of time that if their effort failed, their plan B would be to go out, find a church, and bring a church to the town and seek sewer with a church, because they believe RLUIPA would immunize them from and allow them to circumvent the county's neutral land use regulations. There's an email. If I say JA, I'm referring to the joint appendix. JA 1875 describes Plan B, and JA 2361, after the fact, Mr. Norris says, I warned them that if they refused townhouses, there would be churches on this land. And so these claims have been manufactured beginning with that threat, and after the townhouses were denied, making good on their threat, landowners went out, found a church, and entered into a series of contracts. And the interesting thing here is there was a 2013 contract which was entered into with Canaan, and Canaan terminated that contract as it was permitted to. After investigating the property, like in Andon, it made informal pre-submission inquiries of county personnel charged with processing water and sewer category change requests. And their real estate broker, as the court observed, reported that county personnel expressed huge doubts that sewer would be approved based on the language of the BCN. And they sent an email. And the emails are at JA 2513, JA 2490 that say.
Now, opposing counsel says the county was just wrong about that and incorrectly read the plans, I guess, the plans in the PIP.
The county, Mr. Storzer refers, they refer the court, and it's in their briefs, to one page of the BCNP. And that's appendix page 709. and Judge Richardson looking at. And they refer, and that is the only page that they refer the court to substantiate an argument that Canaan and the other plaintiffs had a reasonable expectation that sewer would be approved. And Judge Richardson was spot on. A sentence that says generally that the plan supports the use of sewer.
Your voice is cracked out.
I'm sorry, there
We're
was
getting background noise here.
There's a sentence, the very next sentence in the BCMP, beginning with the words, the 1997 Fairland Master Plan. Right after the sentence referred to by appellants, talks about how the prior master plan had opened the door to the possibility that one of the properties at issue, it's referred to here as the Benderley property, and that's the property owned by appellant Burtonsville Associates. The prior master plan opened the door to the possibility that that property might get sewer for a special exception use. Then that very page goes on to say, well, this plan is closing the door to that possibility because it's recommending against public sewer for any circumstances. And in pointing out that single page of the BCMP, what else do appellants do? They ignore several other references to their properties on page JA 692, 694, and 695, which say in no uncertain terms, new development to the rural edge neighborhood will be without public sewer. No sewer extensions beyond the commercial neighborhoods, and no public sewer should be permitted for any use, secular or religious. There is no way to reconcile the language of the BCMP and the state law requirement that amendments to the water and sewer plan be consistent with the master plan and extend sewer to these properties. And what better is there to look at what the plaintiffs, the appellants, actually expected at the time is their own contemporaneous writings, not what they're saying now after the fact. Their own contemporaneous writings say, for example, when Canaan terminated the 2013 contract, it said after thorough discussions with attorneys and the county, their own attorneys they discussed this with, and their own assessment of the BCNP, they terminated the contract. That's what they told the landowners at JA 2513 and 2490. And then, notwithstanding that nothing had changed, inexplicably, Canaan entered into a new contract in 2014. And again, what better to look at than their contemporaneous writings to know what they were expecting, what happened. That contract begins at JA 2515, and the recitals to it are very telling. Recital D has an acknowledgement that the properties as they are could not accommodate the church's intended use. Recital E says the sellers recognize, and they're telling the purchaser in this recital of the contract, that the church as a contract purchaser, by virtue of RLUIPA, not by virtue of any county regulations, but by virtue of RLUIPA, brings to their contract a benefit and value which would not otherwise be available to the sellers. And absent having a church as the buyer, would probably consign the property to very limited single family development or parkland. And that's what they've been complaining about for years. They're saying this property under county regulation is not developed. And that's what Burtonsville Crossing complained about to the Maryland Tax Court years earlier, even before the BCNP was done. And what they're saying here is that Canaan helps us circumvent the county regulations because of RLUIPA. Recital F says that there was value added by the role of the church as a purchaser. And what was that value? Well, that's answered by Section 7, which characterizes Canaan as the protectorate of RLUIPA. And as Judge Thacker noted, just like in Andon, Canaan protected itself with a contingency in the contract. But more than that, in paragraph 2A and the contingencies in section 8, the paragraph 2A has an express agreement to sue because they all expected that the request would be denied based on the BCN. Now, in those efforts to manufacture non-existent claims that they didn't expect would prevail based on county regulation that continue today, appellants misrepresent the factual record, pivot from arguments made from the district court to new arguments made here, and ignore relevant language in two master plans. I've just described to you all of the language in the BCNP that they ignore, and they concede there is a state law requirement that makes the recommendations what's set forth in the BC mandatory, legal. State law prohibits the county from adopting an amendment which would be inconsistent with master plan language. And there's no way to reconcile extending service to these properties far into the Pexit Reservoir where service was never as being consistent with the master plan. The BCMP was intended to close the door on any possibility of sewer being extended to properties. Insofar as the equal term claim is concerned, Mr. Storzer points to Glenstone. And again, they're changing their tune from what they argued before the district court. The two relevant bullets from the master plan, which is a different master plan in a different part of the county. It's called the Potomac Subregion Master Plan. And it's not even part of the record because the plaintiffs didn't make it a part of the record. But the two relevant bullets are verbatim, a JA 4142, which is a report by the county's land use expert. And the two bullets, the first bullet on that page at JA 4142 says that sewer is allowed in certain areas generally says that sewer is allowed in certain areas. The second bullet is what they focus on. The first sentence of the second bullet allows sewer in certain areas outside of the sewer envelope at the periphery of it. The second sentence, which begins with the word exclude, says that sewer is nonetheless not permitted in certain areas of the periphery. And appellants now argue that the exclude sentence is comparable to the absolute sewer prohibition in the BCNP. That's why they think it's a compliment, because of that sentence. But interestingly, below, and it's in their memorandum for the district court, and it's ECF 133-2 at page 48. They said affirmatively that Glenstone is not in the periphery, meaning there's no evidence in the record supporting their current assertion that Glenstone is even in the geographic area addressed by the second bullet, because it simply is not. Or stated another way, the Glenstone property could not be excluded from something that it was never a part of in the first place. Thus, the district court was spot on at page 47 of its opinion when it said that as applied to Glenstone, the Potomac plan lacked any of the BCNP's specific language, which effectively barred public sewer in the relevant area. The Glenstone master plan is different. The plaintiffs acknowledge below that the second bullet that they're focusing on now doesn't even apply to Glenstone. It's not in the geographic area of the periphery. And there's no evidence in the record other than argument by counsel to the contrary. Another misrepresentation that they're making now is at page 27 of their reply brief, where they state that the county argued that the landowner plaintiffs lack standing to assert an equal terms claim and that the district court rejected that. That statement is absolutely wrong. for two reasons. First, we didn't make a standing argument. What we were saying is that insofar as the landowner plaintiffs, who are plaintiffs in their own right and have to prove the elements of their claim, an element of their claim for an equal terms claim is to show that they are a religious institution, and they can't do it. So what we were saying is they couldn't prove an element of their claim. And the district court, at page 23 of it, which is a JA 4872, acknowledged the argument we were making and noted that several courts have in fact found that one element of an equal terms claim is that the plaintiff must be a religious institution, but it never came back to that argument because its other rulings were dispositive of equal terms. I want to address briefly the free exercise claim, because there are some new arguments made in the reply brief that we haven't had a chance to address. And they're important. And they make appellants make essentially two arguments in support of their free exercise claim. First, they argue, and I really don't understand the argument, but they argue that they need not be burdened. Well, that's just contrary to case law. In Employment Division versus Smith, the Supreme Court stated clearly that government actions that substantially burden religious practice must be justified by compelling government interest. 494 U.S. at 883. Cuomo, the recent Supreme Court decision relating to the pandemic, doesn't support their assertion that no burden must be shown, because in the context of assessing whether an injunction should issue, which was done in Cuomo, the Supreme Court made an express finding that the governor's executive order restricting attendance at religious services would irreparably harm congregants who could not attend services. So they must show substantial burden. And for the same reasons, they can't show substantial burden on their RLUIPA claim, because all of their harm is self-inflicted by going forward with a contract that they knew would fail. They have no burden to support their free exercise claim. They also argue that the rational basis review should apply to the free exercise claim, which again is simply contrary to binding. They argue, strict scrutiny should apply in contrast to the rational basis review that was applied by the district court. In applying rational basis review to a free exercise claim, this court in Bethel, and I believe Judge Thacker was on that panel, explained that under the free exercise clause, a law that is neutral and of general applicability need not be justified by a compelling government interest, even if the law has the incidental effect of burdening a particular religious practice. And further, that a law is neutral unless its object is to infringe upon or restrict practices because of their religious condition. Mm-hmm. Rational basis review applies here because the BCMP prohibition against sewer for any use is not targeted at religion or religious practices. In fact, it was adopted in the face of a request to build townhouses. And it is neutral and generally applicable in that it applies for any use. Below and here, appellants acknowledge that the BCMP was the sole basis for the denial of the sewer. They may be changing their argument, but in three places they've acknowledged that the BCMP was the sole basis for the denial. Docket 133-2, page 8, note 3. In their statement of facts below in paragraph 179 at JA 283, and in their brief here, their opening brief, page 19, note 5. And thus the focus of their argument below was that the BCMP targeted church use. And the district court characterized their targeting argument as a misrepresentation of the facts in light of the vigorous townhouse campaign they embarked upon during the BCMP process. There simply was no evidence that any challenge decision by the county in this case was made that targeted religion or religious practice. Nor here was there any individualized assessment that might be subject to strict scrutiny. In Smith, The Supreme Court wrestled with whether and when to apply strict scrutiny and therefore deemed presumptively invalid generally applicable laws which impose civic obligations or which are of societal importance. And the Supreme Court there cautioned that a private right to ignore that strict scrutiny, is not a private right to ignore generally applicable laws. 494 U.S. at 87 through 89. All of the cases in which there have been individualized decisions involve, as the Supreme Court explained its earlier decision in Sherber, where that was developed in the context that lent itself to government assessments of the reasons for relevant conduct. Indeed, recently in the Fulton case this year, the Supreme Court said that the creation of a formal mechanism for granting exceptions renders a policy not generally applicable because it invites the government to decide reasons for not complying with a policy. Well, here, there simply is no exception or system of exceptions which invited Montgomery County to consider conduct or make assessments based on different applicants, who they were, or what they did. And so strict scrutiny absolutely should not apply to this case. The district court was absolutely correct in applying rational basis review because there was no such system of individualized assessments in place. And the BCMP took away any discretion there was. In conclusion, I see my time is up. I thank you for the court for its time. I ask that the court affirm the carefully considered of the district court and respectfully request again that affirm the district court's decision. Thank you.
Thank you, Mr. Feldman. Mr. Strozer, you have some rebuttal time.
Thank you, Your Honor. I would like to address the point regarding Glenstone Museum that was made by my counsel. I would refer the court to page 3989 of the joint appendix, MCPPC initial comments on Glenstone.
Bullet points are?
It relates to, it's the evidence demonstrating that the property was subject to the specific restriction, which is in the record at least 3 times, including in the plan itself, which the court can take judicial notice of. Stated, and I'll just quote quickly, it specifically excluded properties adjacent to and in vicinity of the lower Greenbrier branch properties. This property confronts the Greenbrier properties, thus would not qualify in the peripheral sewer service policy. On the next page, footnote 11, quote, this property confronts the lower Greenbrier branch properties shown on page 83 of the Potomac plan. It is therefore excluded from the peripheral sewer policy. That's page 3990 of the joint appendix. And in the statement of facts that was submitted, page 324, paragraph 412 discusses the same issue. So these facts were certainly in the record. With respect to the other unsuccessful applications, the deferred and denied applications.
Are you saying then that Glenstone is in the periphery? He says it's not in the periphery, your opponent. Do you hear me?
It is adjacent to the lower Greenbrier branch.
Mr. Feldman said, I think he was referring to the very same thing you are, Glenstone is not in the periphery. And you now are referring us to a statement about the periphery, but you're not saying that he's wrong, are you yet? Is he wrong or right?
I may be getting a little lost here, Your Honor, but the point is that it was not disputed that the specific recommendation against access applied to the Glenstone Foundation itself. I think that's the critical issue here.
Do you know the answer to the question of whether the museum was in the periphery or not?
It's in the periphery and excluded from the sewer.
And the site that you give that it's in the periphery is what?
page 3990.
Now, is that page 23 of the Potomac Subregion Master Plan?
No, it's not, Your Honor. That's in the Clements Foundation application. I would like to bring up the other proposed uses that were deferred or denied. None of them were PIFs, not even the other church that applied. None of them were done under the PIF policy. With respect to the issue of Andon, the discussion with respect to the contingent lease agreement in the court's opinion there specifically cited Petra Presbyterian Church and said because the plaintiff purchased property with knowledge that the permit to use the property for a church would be denied, the plaintiff assumed the risk of having to sell the property. Again, it was not the fact that they had entered into a contingent contract, it's the fact that they did so knowing that the use was not permitted. I think that's the essential point there.
It strikes me that the various provisions and recitals and agreements to sue in the 2014 contract are evidence of that knowledge, no?
They are evidence of the knowledge that it may be difficult. And this is where we get to the crucial point here. If the regulations allow the use, but you have a local government that nevertheless does not want the use there, their officials do not want it for whatever reason. We have not appealed our other claims alleging discrimination here. But if the use is not wanted, but the regulations permitted, they didn't change the VCNP. They could have done that. They didn't change the water and sewer plan. They could have done that. But those plans allow this use, knowing that government officials are hostile to it and therefore you don't have a claim. That can't possibly be the standard of RLUIPA. All that has to happen, I see my time is up, Your Honor, so I thank you for your time.
You go ahead and finish your thought.
My thought was for a government to simply avoid the strictures of RLUIPA by simply saying, we don't want you, regardless of what our regulations say, and therefore you can't have a reasonable expectation because you may expect litigation, because you may introduce a contingency contract. That cannot be a broad construction of RLUIPA's terms.
Very good. Judge Thacker, Judge Richardson, either of you have any further questions?
I do not.
I do not.
Thank you, Your Honors.
Thanks very much for your arguments. We will take this case under advisement. Madam Clerk, can you put us all on hold and take about a 5-minute break?
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. We will now hear argument in our third case, 2014-18, Fernando M. Smith versus Michael Lee Travel Piece.
May it
Yes,
please.
and,
Go ahead, Judge. Go ahead,
I'm
Judge. Sorry
sorry.
about that.
Mr. Mullins, if you could turn your video on, please.
Oh, dude. Hang on.
Okay, we thought we did.
There. Is that?
It says video broadcast stopped. Sorry.
Mr. Simmons, you out there?
Yes, Your Honor.
Good to have you with us, Mr. Simmons.
Thank you very much.
You may proceed.
All right. May it please the court. My name is Lonnie Simmons. I represent the appellants in this 1983 action. You have a case where the underlying state criminal action with the search beginning in 2014, it took a long time for the underlying criminal case to get resolved. And by the time it was resolved in June of 2018, not only had the state court judge declared the search was invalid and made a lot of very specific findings about that, ultimately the criminal charges were dismissed with prejudice. And the 1983 action that was filed in this case was filed on, let's see here, it was 2019. So it was filed on September 10, 2019, which was less than 2 years after the criminal charges had been dismissed with prejudice.
Now, Mr. Simmons, you say the criminal case started in 2014. What started, whether it was a search warrant, is that correct?
That is correct. Started with a search warrant, yes.
And that's in October of 2014.
Yes.
And you all challenged that in some kind of a mandamus proceeding, that search warrant, that search business. And you challenged that in a mandamus proceeding in the circuit court of Mineral County in November of 2014, correct?
Yes. They filed a it wasn't me below, Judge, but yes, whoever the lawyers for my clients did that.
Yes, it was the folks you represent now.
Yes, okay. Correct. Yes.
All right, and then and subsequent to that, when it was unsuccessful, they filed a proceeding in the Supreme Court of Appeals of West Virginia in March of 2016.
Yes.
That was a year and a half after the search.
Yes, that's correct.
And the Supreme Court of West Virginia affirmed the circuit court of Mineral County.
Yes.
The indictments, that is the beginning of the criminal proceedings, began in May of 2015.
That is correct.
Not 2015, May of 2015.
That's correct.
And then it was more than a year after that, in June of 2016, that one of the defendants in the indictment, Mr. Crabtree, filed a motion to suppress. And then his co-defendant, Mr. Smith, filed a motion to suppress in October 2016. So
yes.
it was 2 years, nearly after the search warrants and affidavits and searches, before the motions to suppress were even filed.
Yes.
Correct?
Okay, so we're up to the dates that the district court judge found to be critical, which was the district court found that the critical dates was June 16 of 2016 and October 21 of 2016, which is the date that the two motions to suppress were filed. And as a result of choosing that as the accrual date, the district court threw the case out, saying that the statute of limitations had expired. And
what do you think we should use as the accrual date, and what is your best argument for that?
Certainly. I think the accrual date is June 4th of 2018. That's when the criminal charges were dismissed with prejudice. That's when my client's liberty interest were finally freed. They no longer had their liberty restricted, and we easily met the statute of limitations using that as the accrual date.
What if your client had never been indicted, such that there was no resolution to any criminal action? There was only an illegal search but no indictment.
Right. It would be a completely different
Would they
issue.
still have a 1983 claim?
Not in my opinion. I think if their liberty interest isn't impacted, they would not get the benefit of the McDonough and Heck line of cases. They would simply be complaining about a bad search, and therefore the statute, the accrual date there would be earlier. But that's
Okay,
not
so
what we
your
have.
distinction then in response to what Appellee argues, which is that somebody who is the subject of a bad search that never comes to fruition would never have the benefit of being able to sue. Your response is that's different because the liberty interest isn't implicated. They could still sue, just not under a 1983 theory. Is that your position?
No. If it's a bad search, they could file the lawsuit earlier for the bad search of 1983 action. Let's say they did.
Why couldn't your client have filed the lawsuit earlier for a bad search?
Oh, they could have.
I mean,
yeah,
following the district court's line of reasoning, you knew it was a bad search or surmised it was a bad search at the time the motion to suppress was filed. So why wouldn't your client be held to that same standard?
Theoretically, you actually can file a 1983 action while your criminal charges are pending and before the search had been declared bad. I mean, I don't know why people would do that in the real world. I've seen.
I guess to meet the statute of limitations, to meet the 2-year statute of limitations is why somebody might do it. So could you respond to how that isn't a violation of the statute of limitations?
You have two separate interests. The one, if it's simply the search, you're complaining that somehow the search is invalid. But what we were complaining about here was the bad search led to our clients being charged criminally. They had to post bond. Their liberty interests were restricted as a result. And McDonough recognizes that even if you're on a PR bond, your liberty is restricted. And that's why, using the logic of Heck and McDonough, our clients had the right, if they wanted to sue over their liberty interest being restricted, they had the right and duty to wait until the criminal charges were dismissed, which is what they did. They waited until after the criminal charges were dismissed with prejudice. And that's what's different between.
But you're saying they could have sued earlier under a different theory.
Under a different theory, yes.
And then then why not sue earlier and amend the complaint?
Well, you could. I mean, I guess you could. I guess it depends on what would happen. You could have a search that's bad, and let's say that for whatever reason, the prosecutor waited 2 years and then said, okay, now we're going to indict you based upon the evidence that we found from this bad search. But once you indict them, you're affecting their liberty interest. And if you're going to sue over the restriction of liberty, you then have an obligation to wait until your liberty interests are freed and the underlying criminal case is resolved in your favor before you can file, which is exactly what happened in McDonough and in Heck. And that's why that line of cases, I think, applies here. The analysis that the courts.
Can I ask it? Maybe I'm not following your argument so well.
Okay.
So Heck and McDonough are cases that are about liberty interests, right? So they're only about liberty interests, right? And so in those cases, you see in McDonough, the court talk about sort of a pre-process and post-process liberty interest deprival, but it's all about liberty interest. Right? What seems different here, and what I'm having a hard time reconciling, and I think what you're identifying is the right line, is that where it's a search, that's a fundamentally different claim. The Supreme Court said that a wrongful search under the Fourth Amendment, is complete at the time of the search, and so let's say, take for a second that you could divide it between the search and a liberty interest. It seems like you must file the suit with respect to the search when it accrues. And I think you acknowledge it accrues before the indictment happens.
Yeah, I agree if that's the only thing that you're complaining about. But the search ultimately, though, led to the indictment. And that's why
how do we know that, Mr. Simmons, by this record? I mean, it appears that way, but is it connected up on the record that what was seized resulted in the indictment? And then how do you get around the fact that the indictment had to be precipitated by the state prosecutor, not by the police officers? Right. The prosecutor had to present it and sign it, and the jury foreman had to the jury had to vote properly, and the jury foreman had to sign it.
Right.
They're not sued or not accused of being done anything wrong.
Sure, Judge. I think the way you make the connection, you look at the sequence of events, and ultimately you look at the fact that the criminal charges were dismissed with prejudice after the judge made those very specific findings about how bad the search warrant was and threw out all the evidence. If there had been evidence independent of the search that could have been used to prosecute my clients, they could have gone forward with that, but they didn't. So they not only wiped out the evidence that was obtained, but they also dismissed the indictments with prejudice. The way the U.S. Supreme Court and this court has analyzed these 1983 cases is that you look at the allegations, and in order to determine which statute of limitations applies, you try to see, well, which common law cause of action is this similar to? And McDonough and Heck.
But before you get there, right? So it seems like it's a two-step inquiry, and I'm curious about this because I think it's difficult. But first, you must identify the constitutional wrong, and then you must identify what the common law tort analogy is. And the constitutional wrong could be one of two things. One is an illegal search, right? And then the other is some illegal trial process. So in other words, you falsified evidence, or you held back evidence, or you lied, cheated, or stole during trial, and that's a due process claim under McDonough. But the Fourth Amendment claim seems different, right? And so it seems like we got to separate those two. To the extent your complaint is about the Fourth Amendment claim, I'm having a hard time seeing why, as you concede, you could sue before you're indicted. And so how does that not suggest that the claim has in fact accrued, whatever the common law tort analogy might be?
The complaint specifically alleged the Fourth and the 14th Amendment. So I did include in the complaint a due process, which is essentially the theory that was used in McDonough. One of the interesting things about McDonough.
All right, but that would suggest, okay, so at least arguably, and we can talk about whether it works, but arguably, to the extent you have a claim with respect to a due process trial violation, then that may go forward. But to the extent your claim is a Fourth Amendment search violation, what I hear you saying is that accrued before the indictment. And so once it's accrued before the indictment, the statute is run here, because that's a separate injury than the trial injury.
I think it's a separate theory. If the plaintiffs here had wanted to assert that, we haven't, because the bad search led to the criminal charges, led to the restriction of their liberty interest, and we had to wait until the criminal case was wiped out with prejudice and resolved in their favor before they could file. That's exactly, and one of the cases that really kind of follows that I cited in the brief, there's it's the Pippin case where part of what happened in Pippin was there was a false search warrant presented to the judges and executed, and as a result of that, they were charged criminally, and that particular court held that squarely fits the fabricated evidence analysis under McDonough. And when courts are determining—
Can I ask you that? Because you make both claims, right? So to the extent you made below a fabricated evidence claim, that seems to make sense to me under McDonough. But it seemed like your primary claim is not a fabricated evidence claim, but is instead that there was real evidence that was unlawfully obtained, right? That's the illegal search warrant. So it's not that they like made up the documents, it's that they weren't entitled to get them, right? And those are two separate claims, right? Unlawfully obtained evidence is distinct from a fabricated evidence. Isn't that fair?
Well, I mean, that is a distinction in the Pippin case. That district court reviewed those as one and the same.
But why? So I understand that you found a district court that did that, but why would you review real evidence that was unlawfully obtained, right? So that violates the Fourth Amendment. It might be subject to the exclusionary rule, right?
Right.
But that's the unlawfully obtained real evidence, which is a Fourth Amendment violation, as opposed to fabricated evidence, which McDonough suggests is a due process violation, right? Not a Fourth Amendment violation, but it's a due process violation, suggested. It doesn't actually hold it, I guess. But McDonough suggests that's a due process because it's about the trial process, right? But those are very different claims that it strikes me when we look at their common law tort analogy look very different. Why should I put those together?
I'm out of time now, but I'll be happy to answer that question.
You go ahead, Mr. Simmons. You answer the questions as long as Judge Richardson or one of the other of us.
Okay. Thank you, Judge.
Go with that red light for now.
Okay. In looking and making the analysis about, okay, what's the common law analogy here? I felt that in the briefs, I cited multiple cases where malicious prosecution actions were based upon false search warrants. That was the actual basis for malicious prosecution. So if you're looking for an analogy under the common law, that's a specific example of how you should analyze it. I do agree, this whole area.
But wouldn't that suggest, and I'll let you stop, but wouldn't that suggest that you don't have a claim if you're never prosecuted? I mean, that can't be the tort analogy. It can't possibly be the right tort analogy.
Well, I don't know how else to answer that other than a bad search warrant, a false search warrant is in fact malicious prosecution. I cited a bunch of cases for that. So when a court's trying to divine, okay, what is the analogy?
It would require, I mean, malicious prosecution requires a prosecution. And we all acknowledge, I think, that if you have a bad search warrant and you are never prosecuted, that you have a Fourth Amendment 1983 claim.
Your Honor, I suppose it depends on what you mean by being prosecuted. My clients were prosecuted. They spent years with their liberty.
I understand your clients were prosecuted, but what I'm talking about is that you have a Fourth Amendment claim, hypothetically, not your clients, if you have a bad search warrant and then you are never prosecuted. You can still bring a Fourth Amendment claim, right?
If you wanted to file a claim before the criminal case was resolved, I guess.
No, I'm saying there is no criminal case. No criminal case is ever filed. I mean, there are bad search warrants that don't result in indictments, right?
True, that's true.
And if that's true, you could bring a Fourth Amendment 1983 claim in the absence of any prosecution.
True, that's true. I don't disagree with that. I'm with you.
All right.
I know I'm out of time, so I'll mute.
Thank you, Mr. Simmons. Mr. Mullins, you out there?
I am, I believe so. May it please the court. My name is Michael Mullins, and I represent Trooper Travel Peace in this case. And we urge the court to affirm the decision of the lower court and dismiss this case. And the court hit the nail on the head when it was asking Mr. Simmons questions about when this case accrued. And if you look at this court's prior decision,
what's your position on that? When did it accrue?
It accrued at the time of the search and the seizure, and one needs to look no further than the complaint to see that. If you will look at paragraph 9 of the complaint, which is at Joint Appendix page 11, the plaintiff specifically pled The crux of this case is the economic and other damages suffered by plaintiff when being the accrual, the state of West Virginia, through the affidavit submitted by the defendant, obtained an invalid and overly broad search warrant. So they're telling you when it happened, and we know that was in 2014 when the search warrant was obtained, and they're telling you what happened.
Let me ask a follow-up to that question. The wrong is, the constitutional wrong here was an illegal search. And at least traditionally in our country, illegal searches were challenged by trespass actions, right? Which is an unauthorized entry into property. So why don't we think about the common law tort analogy in a search case as being trespass? Maybe it's trespass to chattels. If you're taking things, we could debate the nuance, but why isn't it trespass? Is that the right common law tort analogy? Or do you think it's malicious prosecution as well?
I do not think it's malicious prosecution. There's nothing about the complaint that pleads any type of malicious prosecution claim. And I think that's what's important. And that's exactly what Judge Grove found.
What is it, trespass?
If it is a trespass, and I could see that being a trespass, it would fall within the 2-year statute of limitations. 2 years under West Virginia law, within the time of the trespass, the claim, the statute of limitations would bar the claim.
Right, and the idea there being that the trespass, the claim accrues at the time of the entry, but there may well be a discovery rule that tolls that accrual if they didn't know it was illegal at the time. So if they didn't have the affidavit, the claim may accrue at the time of the trespass, but the discovery rule might mean that it's tolled until the knowledge is had. Is that fair?
Even if the court takes that analysis, the plaintiffs knew of this, at least at the time when they filed their motion to suppress.
I agree. I'm just trying to understand the framework. I'm not disagreeing with the conclusion of the framework. I'm just trying to understand the framework.
Yes, I agree.
Well, so in practice then, if a bad search, the claim accrues at the time of the motion to suppress, and it's 2 years, and many criminal prosecutions last far longer than 2 years, that may necessarily mean that everybody will need to file a motion to suppress and a 1983 action at the same time in order to make sure they don't miss this 2-year statute while they're defending themselves against the criminal action. Is that what we want?
Well, I think that's what the law demands, but I think that the accrual date is actually
for
the
a lot
search.
of business.
He's a lawyer. That's not a bad thing for him.
Yeah, the search date is the accrual date, not when they filed the motion to suppress, but the motion to suppress demonstrates their knowledge. It doesn't start the time frame. It demonstrates that they at least knew it by that date, and that's what.
So, in order not to miss a 2-year statute of limitations deadline, anytime someone has reason to file a motion to suppress or questions the validity of a search warrant, they need to file a motion to suppress and a 1983 action on the same day.
Yes, if they believe that the search was unreasonable or unconstitutional, they need to file that within 2 years of obtaining that knowledge.
And that's sort of what Wallace tells us, right? So Wallace says that may well happen, and then courts have the authority to stay those actions or do what they need to during the pendency of any criminal action. I mean, that's sort of Wallace itself, right?
Exactly. And if you look at page 183 of Wallace, it says, "We gather that if such claim properly may go forward, despite the lack of disposition of the criminal charges that are unfavorable to the 1983 plaintiff, then the claims must have accrued." And that's exactly what we have here. The flip side of this, if you think about it, had they filed this claim timely, the defendant could not have said, whoa, 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 this case needs to be dismissed because the conviction hasn't been overturned. And so that demonstrates conclusively that the claim had in fact accrued at the time of the search. And so I think that's what's important here. And if you go back to the complaint.
Can I ask you then a follow-up question?
Absolutely.
So I'm on board with the search claim, but at least on appeal, your colleague also has a fabricated evidence argument, right? And I think after McDonough, we got to look at that differently because, you know, the sort of steps that Manuel versus City of Gillette and others tell us is identify the constitutional right and identify the common law tort analogy. But the common law or the constitutional right there suggests a due process violation, right? If I'm manufacturing or fabricating evidence as opposed to unlawfully obtaining real evidence, that sounds like a due process claim. And that would not accrue. That does sound like a malicious prosecution claim. So why shouldn't we find the Fourth Amendment allegations are time barred, but the malicious prosecution allegations, that being the due process allegations, are not time barred?
It's because when you look at the four corners of the complaint, which what must be looked at here, just like the lower court did, the allegation of the fraudulent evidence is specifically noted to be fraudulent statements in the affidavit in support of the search warrant. There's no allegations in the complaint of anything done after the application for the search warrant that was fraudulent or a misrepresentation. So
is there any allegations in the complaint? I mean, I don't see it, but I'm just trying to make sure I understand fully. Does the complaint allege that during the search warrant, they manufactured evidence as opposed to unlawfully seized evidence?
It's just an allegation of an unlawful seizure based upon a predicate that they allege that the search warrant was improperly obtained. They don't allege that any evidence was fabricated and produced to the court. They allege that the evidence that was obtained.
Do you agree?
They don't allege anyone put anything phony in there or anything like that. It's all about their entire claim is all about getting to the warrant.
Do you agree if the scenario was different? So if we went back and there was a new complaint and it alleged an unlawful search warrant where they unlawfully seized evidence, and in addition, the prosecutor manufactured or fabricated evidence. In that scenario, if it's properly pled, is the distinction that I'm talking about correct? The Fourth Amendment search claims would be time barred here, but the fabricated evidence claims like in McDonough would survive?
I agree, and I think that's exactly what happened in McDonough. There was an allegation that the prosecutor introduced false evidence knowingly at the trial. And that's not what we have here. All the allegations of any impropriety occurred in the application for the search warrant when you look into the complaint. And I think that's the distinction here that we've got to look at. All the Heck decisions and all the decisions that follow Heck look at, they look at the four corners of the complaint and they draw an analogy to the closest common law action. And here, three different times in the complaint, again, I already talked about paragraph 9, but in paragraph 35, and then again in paragraphs 33 and 34, they talk about the alleged impropriety was in the application for the search warrant, which is time barred here. There's no allegations. The words malicious prosecution don't exist in the complaint. There's no allegations of the complaint of any conduct by the officer that was illegal, immoral, or otherwise after the application for the warrant. The word warrant is in the complaint about 30 times. The word illegal search is in the complaint about 30 times. We're talking about an illegal search, an illegal warrant claim here that Mr. Simmons acknowledges they could have filed 2 years after the search warrant was applied for. And when you go back and look at Brooks, it says if they could have filed it, then it accrued at that time. And if it accrued at that time, they've missed their statute of limitations. And therefore, this court was, the lower court was right when it dismissed this cause of action.
You're saying there's no allegation of fabrication of evidence or false evidence presented to the grand jury?
That's not in the complaint. There's no allegation of that.
That's what I'm talking about. In the complaint, is there anything alleged about deception of the grand jury or the deception of the prosecutor or anything like that?
No, Your Honor. There's nothing in the complaint that references anything that happened improper during.
Does it even allege that your client, Mr. Travelpiece, testified in front of the grand jury?
I believe that the complaint references that he testified in front of the grand jury, but it does not reference that he testified falsely in front of the grand jury.
Okay.
Then the only other point that I'd like to make, unless the court has additional questions for me, is that, you know, the Heck case is very specific in when it applies and when it doesn't apply. And what it says is that the Heck decision only applies when a judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction. And that's exactly what Judge Grove talked about in her opinion on page 7 of her opinion, which is at Joint Appendix page 168. She specifically said Heck only applies when a judgment in favor of plaintiff would imply the invalidity of his conviction or sentence. And then she went on to discuss how here Heck does not apply because had plaintiff filed this claim for an illegal search, an illegal seizure, it would not have implied the invalidity of his conviction. And the court went on to note, and again, I think that's what's important, and it coincides with what we talked about with Brooks. The court went on to note that on page 7 of the opinion and page 168 of the Joint Appendix that plaintiffs could have filed a civil action against defendants while their criminal proceedings were ongoing because the result of their 1983 claim would not have invalidated their conviction or sentence. And again, the other thing that I think is important about Judge Grove's opinion is when you look at page 6 of that opinion, which is on Joint Appendix page 167, she talks about how the district court judge looked specifically at the allegations contained within the four corners of the complaint and found that based on the face of the complaint, plaintiff's 1983 claim only concerns defendant's conduct during the search and seizure. And Mr. Simmons has acknowledged, because he has to acknowledge, that that search and seizure claim, which is the claim that's made in the pending civil action, could have been made within 2 years of the search and seizure. And under Brooks, because it could have been made, that means it accrued. And because it accrued more than 2 years prior to filing the civil action, it has to be dismissed, and this court should uphold the lower court's dismissal of this case. If the panel doesn't have any more questions, I would rest on our briefs and the arguments that we've made here today.
Very well, Mr. Mullins. We appreciate it. Mr. Simmons?
Yes, Your Honor. Okay, thank you. I wanted to point out a couple of things. In McDonough on page 2159, they talk about, this is when they're trying to distinguish Heck and Cato or Wallace, the decisions. And the court says, by contrast, a claim like McDonough's centers on evidence used to secure an indictment, which is exactly what we have here. And it goes on, and at a criminal trial, so it does not require speculation about whether prosecution will be brought. It directly challenges and thus necessarily threatens to impugn the prosecution itself, quoting from Heck. That's why McDonough McDonough followed Heck.
McDonough's about fabricated evidence, right? It's not about true evidence that was unlawfully seized during a search.
The distinction between the allegation and the complaint, and this is what some courts put different labels on these causes of action. There are several courts that call this judicial deception. The complaint specifically talks about judicial deception, and that's when a false affidavit is presented to a judge, and the judge accepts these false representations, these incomplete representations. The officer knew stuff, but he didn't include it in the affidavit. It turns out the judge even said there was never any basis for probable cause here. And when you look at the allegations that were made, there wasn't even any crime here. And based upon that, that's why they make the analogy to malicious prosecution. That's the closest analogy.
Can you respond to your colleague's suggestion that the complaint includes no suggestion of fabricated evidence after or related to the execution of the search warrant?
After the search warrant, all of the lies to the court, misleading statements to the court, incomplete statements to the court, whatever label the judge put on it, occurred with the affidavit. The affidavit triggers a search warrant, and then they took everything from this business and essentially shut the business down. So that's what we're dealing with here.
So there's no allegation in the complaint dealing with impropriety that occurred after the search warrant, after obtaining the search warrant.
That is correct. That is correct, because once you have the bad search, then that evidence is used to indict my clients, and then their liberty interest is restricted. They then had to wait for the criminal process to be completed using the malicious prosecution analogy before they could file the complaint. Their 1983 action here.
So you're saying the indictments and the proceedings relating to the motion to suppress had the effect of tolling the statute of limitations for the bad acts?
That is correct. Under Heck and under McDonough, that's exactly right, Judge. That's the argument. We'll have to see how the court does it.
Judge Groh said it's all based on the search warrant affidavit, which you agree, and the search. And the 2 years expired in 2016, from 2 years from the date of the search warrant.
Yeah, Judge, under that analysis, if you actually went from the day of the search, the statute ran, I guess, before the motion to suppress was filed. So the district court judge at least
after the motion to suppress were filed.
Okay, right.
One was October 23rd, 2014, for the search activities, and second motion to suppress was filed October 21st, 2016.
Right.
But after the indictments.
Right.
But
right.
Okay. Position, counsel, let me ask this question just because it seems like there's maybe a little line. I sort of read the case law suggesting that the claim accrued at the time of the search, but the discovery rule meant that it was effectively told until you knew enough to know that the search was wrongful. And we don't need to determine what date that is. And I guess at some level, it doesn't matter which of those dates govern here because they're both too late. But do you have a position on which way we think about that? I mean, we normally think about the accrual happening when the injury and the wrong occurs, but the discovery rule means that if you don't know about it, you don't have the obligation to bring the claim until you learn of the facts, or maybe should have known of the facts that would give rise to the claim.
And Judge, I see I'm in the red now, but may I answer that question?
Please.
You answer the question. Go right ahead and answer the question, Mr. Simmons. That's fine. Don't hesitate.
Okay. Thank you, Judge. I don't review view the district court's opinion as saying that there was some discovery rule that made the statute run from the date of the search to the date that they filed the motion to suppress. Anyone who practices criminal law enters the search are going to file a motion to suppress. I don't know that criminal defense lawyers are so omniscient that they actually know all the facts at that time. That's why they ultimately had a hearing where where the state trooper was under oath. And then once the circuit court judge heard all that evidence, he issues his order in February of 2018 saying all the findings that he made about how misleading and inaccurate the search warrant was. And then that's what caused the whole thing to be dismissed. So I don't.
Then isn't that where the discovery rule comes into play?
Okay, yeah, at that point, I think arguably that's right, and I think that's and it's also, and that's why I think it's similar to. That's why the courts are saying it's similar to malicious prosecution, because they like to use the date that the criminal charges were resolved in favor of the client. So, unless you have any other questions, I'd respectfully ask the court to reverse the district court so we could go ahead and develop the rest of the facts.
Thank you, Mr. Simmons. We appreciate it very much, and thank you. And thank you, Mr. Mullins. Good to have both of you with us. We appreciate having good West Virginia lawyers, especially Thacker and I.
I do too.
Mr. Richard gets the benefit of your help. So we'll take this case under advisement, and Madam Clerk, we'll call the next case if the lawyers are available.
Our next case is 2017-45, Rogers Morgan versus Caliber Home Loans Incorporated.
Good afternoon, Your Honor.
Mr. Robinson?
Thank you, Your Honor. My name is Philip Robinson. May it please the court. I represent Patrice Johnson and Rogers Morgan. This case concerns the Real Estate Settlement Procedures Act servicing provisions, specifically at 12 U.S.C. 2605. For purposes of today, when I say RESPA, I mean the RESPA servicing statute. The court below dismissed plaintiff's complaint, the appellant's complaint, and didn't address the merits of their claims. The merits of their claims deal with the credit protection provisions of RESPA and the companion regulation. The court considered and looked at the plaintiff's qualified written or correspondence, which plaintiffs aver are qualified as qualified written requests or notices of error under the regulation. In the joint appendix extract at 82 to 85 is Mr. Morgan's correspondence, and a complete copy of Ms. Johnson's correspondence is at joint appendix 129 to 134. I point that out as to Ms. Johnson's because below Caliber didn't, it's also in their motion to dismiss, they submitted a portion of her correspondence, but not the complete correspondence. The district court dismissed the case, finding that she didn't need to reach the merits of the appellant's claims because neither correspondence in the court's view at the motion to dismiss stage qualified as a qualified written request under RESPA or a notice of error under the companion regulations. And we think that was an error, and we would ask the court to reverse that ruling to permit this case to go forward. Now, there are few and far between cases from this circuit and other circuits addressing the scope of the qualified written request provisions under RESPA since it was amended under the Dodd-Frank Act. But we think, as we do with all statutory analysis, looking at the statute as a whole, the particular subsections that are involved here are subsections E, K, and J. And starting with the statute, looking at the statute, both correspondents qualify as correspondents entitled to the protections under the statute. E is the qualified written request provision that was not amended specifically in Dodd-Frank in the context that's before the court today, except for the timing of certain correspondence in response to letters. Dodd-Frank added subsection K. Subsection K defines what standard mortgage servicing duties are. And in the context of the older case law, it expanded the scope of what RESPA covers. In particular, not only does RESPA cover the collection and allocation of payments from mortgage borrowers and payments to investors on mortgage loans related to mortgage servicing, but RESPA also covers.
Counsel, I hate to interrupt you and to sort of jump around, but I got two sort of specific questions with respect to the notice of error. And you seems like you argue that it falls under 1024-35B7. At least you suggest that in your opening brief. And do you think, is that true? Do you think that Mr. Johnson's claim falls under B7?
Your Honor, Miss Johnson's.
That's
fine, Your Honor. Miss Johnson's correspondence, we think, qualifies under the statute. But to answer your question, we do think it falls under B7 in the regulation as well as B11.
Okay, so help me on B7 to understand why you meet the requirement of addressing 1024.39, right? Which is not loss mitigation in general, right? But is a very specific requirement of servicers merely to provide information about loss mitigation options.
Right, and it's actually, Your Honor, accurate information at the early intervention. And you can see from the well-pled facts, Your Honor, she, like many other families, her family fell behind on their mortgage. They applied for a loan modification. They were approved for a loan modification, she was, and she made all of the trial payments. At no point in that early process, that early intervention process, that we think—
I understand the facts, but can you tell me specifically why you think what you're describing falls under 1024.39?
With the 39, Your Honor, is the servicer has to provide accurate information, early intervention information to the borrower. Here, there was no discussion in the early intervention to Ms. Johnson that she could not be considered for a loan modification based on—
No, but that's the difficulty, right? So that's the specifics, right, of whether they correctly evaluated her eligibility for loan modification. But 39 doesn't address whether they've correctly evaluated her, but is instead very specific written notice about the availability of some loss mitigation.
Right. And in the conclusion, it's easier for her claim, Your Honor, and I concede, Your Honor, that it is difficult, but it is easier to understand her claim that they didn't offer her accurate, that's the key word that's required in 39, early intervention information, because of the conclusion that they reached at the end, which was she was not eligible based on a legal error. So now, if the court finds that her correspondence doesn't qualify for B7, we certainly think that it falls under the catch-all, any other error related to mortgage servicing in this circumstance, that they made a legal error in evaluating Ms. Johnson's loss mitigation application by concluding that a fixture lien would take a priority over the real property lien.
So help me understand, and I'll stop and let you get back to your argument. These are just the two things that I wanted to make sure that I understood. Is that when we look at the Federal Register, it says that a failure to correctly evaluate a borrower for loss mitigation is not a covered error under the final rule. It does not fit under B11, right? So that's what the agency is telling us. Right, so I understand you want to say, well, maybe we can come up with a way for it to do it. I don't see that either. But don't we have to give deference to the agency who tells us, no, the failure to correctly evaluate a borrower for loss mitigation is not covered there?
The agency doesn't quite go as far as Your Honor's summary is provided. The agency does say you may not use the notice of error process for an appeal of a loss mitigation denial, which is exactly—
Right, so let me read it and tell you whether I'm wrong. The Bureau declines to add a servicer's failure to correctly evaluate a borrower for loss mitigation option as a covered error. I'm just not sure why that's ambiguous.
Well, Your Honor, because if you read her correspondence, she's not asking for them to review their decision to deny her. She's asking them to correct their policy and practice and procedure that assumes a fixture lien takes a priority. There's a distinction, and the regulations go further in the commentary. That's what Your Honor's looking at. So into the commentary. The commentary doesn't say that you can't address issues that may arise out of loss mitigation in this context. But the commentary goes further, and just as Ms. Johnson did, simultaneously to this correspondence that's before the court, she completed her appeal under 1040, the 41, and appealed the denial. That's how you appeal the denial. And she did that in a separate process. The complaint lays out that she did that and was successful. And this, in what she's doing in this correspondence, is asking for information for why they determined that a fixture lien would take a priority under Maryland law over the mortgage. And so we think in that narrow sliver. Now, we've asked the court to take notice of the CFPB's amici brief in this pending Second Circuit case. They lay out, Your Honor, a rule, Judge Richardson, to answer your question. If in the rule that the CFPB lays out, and they go through the same official commentary that I just outlined generally and you quoted from, but they lay out a rule that goes something like this. If the QWR can be answered without reversing a decision on loss mitigation, it's permissible. Now here we don't have a situation where Ms. Johnson did not exercise her appeal rights under 41 simultaneously, but let's assume she did not. And she just did the qualified written request, and she asked for them to reverse the denial of her loss mitigation. That would be improper, Your Honor. But in this instance, it's not improper because that's not what she was asking for. She was asking for them to understand that they had made a legal error. And the reason she's still a borrower.
But not to reverse that legal error.
It's not in the correspondence. That was the avenue to do that legal error and reverse the denial of her loss mitigation was through the appeal process on loss mitigation. That's not in this case. She also asked in the correspondence for information they used to make their decision. Why would a borrower do that and do this simultaneous track as Ms. Johnson did? Because she might need to supplement her appeal once she understands how they came up with this decision. You can see in her correspondence, she provided the citation to the guidelines governing her loan, and she provided the citation to Maryland law that don't support the conclusion. But perhaps Caliber had some other basis. So she asked for that information. And in the real world, practice world, if they had come back with something, then she could have supplemented her appeal that was then pending. And we don't, in addition, so that sort of jumps to the regulations as to Ms. Johnson. Under subparagraph K of RESPA, the Dodd-Frank expanded inquiries and standard servicer duties to prevent foreclosure. And loss mitigation is a bread and butter way to prevent foreclosure. So the district court's ruling that any QWR or notice of error related to loss mitigation is not proper can't be reconciled with the fact that Congress expanded the scope. And when you read E, K, and J together, clearly loss mitigation is subject to servicing, and a borrower should, in this instance, not ask for an appeal, but be able to address those questions. Now, Mr. Morgan, his letter, his handwritten letter, is pretty specific, and he addresses different problems. He's talking about the loan balance on his loan. On the one hand, as of one date, their loan balance is alleged to be $16,000. Then he calls on the telephone on another date, and it's $30,000. He asks Caliber to correct its records. He says, quote, "Your offices are reporting this wrong amount to this credit agency is affecting my employment." He has addressed a specific error. Now, the court below found that wasn't specific enough, or in essence, it was overbroad. But he didn't just do his letter, he also attached the credit report. And looking at J84, the credit report confirms the conflicting balances. And he specified the days that he was told a certain balance. And interestingly enough, on the credit report is the same loan reported by the prior servicer with a zero balance. That is a legitimate QWR notice of error to be sent by a borrower. Although it was in hand and maybe a lawyer might have written it differently, it provides enough information that Caliber knew of the problem. The statute does not exempt very few correspondence from a borrower, except you can't write a QWR or notice of error on a coupon, and you can't write on some other written statement like a periodic statement from Caliber. You have to write other correspondence. That's the only exemption in the statute, and it has to be in writing. So the case law, the circuit case law, that sort of confirms that both these correspondence qualify, and the court below, was in error. You could look at the Medrano case that says there's no magic words. The Catan case from the Seventh Circuit, no magic words. The Poindexter case from the precedent from this court says facilitating loss mitigation is a standard servicer duty. The Finster case, 11th Circuit, there needs to be no absolute clarity in the correspondence for it to qualify as correspondence. And we would ask here that the court look at the correspondence that's provided. It qualifies under the statute and the regulations, and the court below's summary decision. May I continue, Judge King, and just conclude for my opening?
You're fine.
That we'd ask that the court reverse the summary decision below, that neither of these correspondence and all the inferences pled in the complaint related to them in a light most favor to the plaintiffs, in the court below should be reversed. These correspondence qualify as qualified written requests and notices of error, and they should be able to reach the merits of their claims that weren't addressed below. Unless there's any other questions, I'll save my time for rebuttal.
Very good, Mr. Robinson. We appreciate it. Mr. Fitzgerald?
Yes, Your Honor. May it please thank you. May it please the court, Matt Fitzgerald on behalf of Caliber Home Loans. This case can be resolved and the district court properly affirmed on the basis of two straightforward holdings. First, the Morgan letter is not a QWR at all. And second, the Johnson letter does not dispute any payment. Now, to be clear, the sole provision of RESPA at issue in this case is the credit reporting suppression provision. That provision requires a letter to be a QWR and also to dispute a payment in order to trigger that provision. The Morgan letter fails at step 1 and the Johnson letter at step 2. Now, to start with the Johnson letter, there's been a fair amount of discussion already about whether it qualifies as a notice of error, and it does not for the reasons provided by the CFPB. Opposing counsel argues that the letter isn't really disputing the denial of a loan modification. I believe that it is. It's in the record at page 87 to 88. She says that the error, she says, quote, "It would seem to be an error on your part to say that providing me a modification that I am qualified for is not permitted because of title issues." And then she says, "Please correct your errors." But ultimately, even more straightforward than this is a finding that the Johnson letter does not dispute any payment. Both Regulation X and RESPA on its face specifically require that to trigger credit suppression. RESPA section 2605E3 requires a QWR to be, quote, "related to a dispute regarding the borrower's payments." And Regulation X says almost exactly the same thing. It only pauses credit reporting, quote, "regarding any payment that is the subject of the notice of error." The Johnson letter is not about any payment. She says, and it seems undisputed, counsel has also said she had a mortgage. She fell behind in her payments, undisputed. She was offered a loan modification, undisputed. She made the payments under the loan modification, undisputed. She failed to get a loan modification at first because of a problem totally unrelated to her payments, confusion over the solar panels lien. The CFPB has been clear that that is properly addressed by the regulations, section 1024.41. And as counsel has said, she actually followed that path, totally separate from this one, took her appeal, prevailed, got the loan modification that she wanted. Essentially, the statutory scheme worked just fine. But that has nothing to do with disputing a payment and suppressing credit reporting, which is the sole provision of RESPA that Caliber has been sued under in this case.
Counsel, does the record include the report that your client made to the credit reporting agencies?
Your Honor, the letter from Mr. Morgan immediately after it in the record, which is, I think is a JA 84, it includes a one to two page, looks like a printout from a credit reporting agency.
But it doesn't have what you sent to the credit reporting agency is what I'm asking.
No, not at all. No, Your Honor. So turning to the Morgan letter, the Morgan letter is not a QWR at all. RESPA defines QWR, and one of the things that it requires in order to be a QWR is, quote, a statement of reasons why the account is in error. And what this letter has is essentially it says, a year ago, someone else, a third party, not you, says I owed $16,000, and today you say I owe $30,000. Please correct your records. You're reporting the wrong amount to the credit agency. But
why isn't that a statement of error? You are reporting the wrong amount.
Your Honor, it's not a, quote, statement of reasons that the account is in error. The numbers are not even in conflict. There isn't any conflict on the face of owing $16,000 1 year and $30,000 on the same loan a year later. In fact, in his complaint, he points out that his loan payment was about $1,100 a month. So it actually makes good sense that that could change like that over the year. And he doesn't say, I think the $16,000 is right.
Wait, that you would owe more a year later than you did a year prior?
Yes, exactly.
That makes sense?
Yes, certainly. If no payments are being made, there would be taxes, there would be insurance, and there would be the absence of payments that could easily be building up at that sort of level. But it's also quite notable, of course, what isn't in the letter. He doesn't say, I think the $16,000 is right and the 30 is wrong.
Can you go back? You just make sure that I understand that. So if I like round numbers, can we use 1,000 instead of 1,100? So if I took a year where I failed to make $1,000 payments, those $1,000 payments wouldn't add to the loan. There might be taxes or other things, but the failure to make those payments wouldn't add to the loan. They would only serve to not subtract from. So I'm having a little hard time seeing how we get, just by failure to make a payment, how it goes from 16 to 30.
Well, Your Honor, it could go, so there would be taxes and insurance, which would be on the full value of the house, essentially. I mean, potentially those alone could be as high as $14,000. There also could be issues with, I think there could be reasons why 16 could change to 30 over the course of a year if no payments were made.
What other than taxes and insurance? I mean, just hypothetically, I'm not suggesting you know the answer to this, but you're more familiar with this field than I am, to say the least. So what could it be? Taxes, insurance. I guess there could be penalties for failing to make payments, but what else could it realistically be?
Well, Your Honor, I think the interest, the unpaid interest would be accruing also during that time. So normally if you were making payments, the interest would be, you'd be chopping away at the interest. But if you weren't making the payments, the interest would be increasing as well.
Well, this letter provides enough for Caliber to notice the error, I would think. Couldn't Caliber identify the account of Mr. Morgan based on this information? Talk to Thomas and provided the ID number of the person he called. Doesn't Caliber have records of those calls?
Yes, certainly, Your Honor. So part of the definition of a QWR is it identifies the borrower and the account. And we're not saying that this doesn't identify the borrower or the account. It's that the next part of the definition of QWR requires a statement of reasons why the account is in error. And that's what's missing here, because he doesn't say that the 16 is right and the 30 is wrong, or the 30 is right.
Well, what does please correct your records mean then? You don't correct unless something is wrong. You don't ask somebody to correct it unless something's wrong. And the two numbers don't match each other.
Right, Your Honor. But of course, over a year's time, you wouldn't expect them to match each other. But I think there's no difference.
I sort of would.
You wouldn't expect them to double either, would you? Judge Thacker's
well, they could, Your Honor, I'm sorry.
I say Judge Thacker's got you in the corner.
Well, so, Your Honor, here's another thing to keep in mind here. The complaint in this case, in the complaint, Mr. Morgan actually gives a statement of reasons why he thinks this account is in error. He says, this was a 15-year loan and I paid it off years ago. I actually owe nothing. And so if you think about that, which he's now pleaded in the case, and then you look at this letter and you say, what in the letter that he sent us would have invited us to look for that error, would have specifically identified that error and given a statement of reasons, there is no such thing. So that just shows.
So do you think it would your claim be different if in fact the error that was being alleged is that it should be 16,000 instead of 30? You might be able to divine that from the information that's provided. But your point is a different one, which is because he's claiming neither 16 nor 30 is the correct number, that there was no way or not a reasonable way for you to determine that.
Yes, Your Honor. So essentially what I'm saying is he's pleaded himself even backwards from the letter, because now that we have the pleading, we know what his actual issue was, what his actual concern was, and what his statement of reasons was. And there's nothing that would suggest anything like that in the letter. And perhaps, I mean, arguably.
Specifically that you're reporting the wrong amount to the credit agency.
Right.
He says amount, right?
And what's so unclear about that is, of course, the lower amount is the amount that he seems to be saying we reported to the credit agency. So it's almost, the letter may grammatically suggest he thinks 30,000 is the right number, but it's odd that he would be contacting us to say your current number is right. It doesn't quite make sense. And that's our point.
You all are.
Because it's an error, and that's what he's. Go ahead, Judge King.
You all are using what they used to call in the law code pleading. Before we had the rules of procedure in the court system, some states still have. They have what they call it. Some countries code pleading. You got to get everything exactly right and allege it in true form. And you can't do anything. And this is just merely a federal regulation that when you're dealing with lay people.
Well, certainly, Your Honor. But of course, what I'm saying is if he had said what he said in the complaint in his letter, it would quite clearly qualify as a QWR. But there isn't any real difference. I mean, anyone can write a letter that says, this is my name and my account is in error, please correct your records. That lacks the quote statement of reasons that's required in the statute.
But there's more in the Morgan letter than what you just said. There are dates and amounts that differ, the name of a person that Mr. Morgan talked to, the ID number for that person. And you were saying that maybe you could get to the $30,000 amount in a year if payments weren't being made in a year. But it also says $630 on my account in late charges. Do you only charge $50 a month for late charges?
Well, Your Honor, it's not clear. The late charges could be
$52 a month for late charges.
They could be more than that, Your Honor. I think it depends on, it's unclear what he means by late charges, but we're.
Well, no, I'm just asking, it was really going back to you saying this amount could be $30,000 because if he didn't pay for a year, then the amount would go up that much. But if he didn't pay for a year, the $630 late charges would have been much more, I would imagine. So I was just pointing out what I see as maybe a flaw in your analysis as to what those numbers might mean.
And he's clearly trying, I'm sorry to interrupt you, Judge Thacker, but he's clearly trying to give you information, good information. He even gives you the name of the person he talked to when he called you with an ID number, 27662, and specifically gives you the amounts that's the fellow Thomas that gave him the 30,000 and the 630. He's giving you information, and once his record's fixed.
He is, Your Honor, but there isn't adequate information in here to pinpoint the error and to investigate it. And I think maybe if we look a little bit more broadly at the statute, 2 points. One is this term statement of reasons. So we're trying to figure out what is an adequate statement of reasons. The exact same phrase, statement of reasons, appears in the immediately following provision of RESPA, E2, where it requires a servicer to give a statement of reasons back to a borrower in response. And so when asking what is good enough to create a statement of reasons, when we look at this letter, which is difficult to make sense of, we've been going around and around about it.
Well, if you just called Mr. Thomas, whose ID number is provided, who presumably works for Caliber, I'm sure Mr. Thomas or Ms. Thomas could help clear it up.
Well, but Your Honor,
you said it was difficult to investigate, but there's a Caliber employee's name and ID number in the letter. So why can't you investigate it?
Well, Your Honor, I don't think he's asking us to investigate Thomas at a certain ID number. He seems to be trying to say something is wrong with my loan balance.
No, I know. You said that. Yeah, I understand. I thought you said there's nothing to investigate. You can't investigate it, and you can't investigate what the problem is here. But you can, because you can just start with talking to your Caliber employee, last name Thomas, ID number 27662, and look at their records on September 20th. I bet they have the account number in their records.
Yes, Your Honor. I mean, we can identify the account, but for the purposes of the rest of RESPA, the reason why the statement of reasons requirement exists is it requires borrowers or servicers, to respond very quickly. Within 30 days, they're supposed to respond and say, we've looked into this, there is an error or there wasn't. Here's our statement of reasons why it's right or wrong, and to investigate it that way. And for someone to say, essentially, here's what you say my account balance is, you're reporting the wrong amount, go, is not an adequate statement of reasons there, any more than if the servicer wrote back and said, we talked to Thomas and he still thinks it's 30,000. That wouldn't be a statement of reasons either, coming back from a servicer to a borrower.
So how would you have us, just give me sort of how would you have us interpret a statement of reasons? What is required, both from the borrower in E1 and the servicer in E2? What would your interpretation of that phrase, which obviously the statute requires of both, what would it mean?
Your Honor, I think it means that coming from the borrower to the servicer, it's supposed to be a pinpointed error such that there's a concrete thing, a specific thing the servicer can look into and respond within 30 days. So in other words, if he had said in this letter, which he clearly knew because he pleaded it later, these account balances are wrong because I paid off this whole loan 2 years ago and I actually owe nothing, boom, that's plenty. That's plenty. And so because he has that in his complaint, it just shows how short this letter is, because no one would think to investigate, looking back multiple years to the previous servicer, did he pay off this whole loan? You wouldn't know or think that based on this letter. And that's why it falls short of an adequate statement of reasons. Similarly, I think coming back from the servicer to the borrower, the servicer would be likely to be sued if they just said, here's the number flat out. The whole point is, here's the number, we show that you've paid these payments on these times, here's where we come to this number. That is what the servicers do and what's expected of them.
So the point being is that you can't just show an error, you must state the reasons for why it's an error, right? The statement of reasons is a why question.
Yes, Your Honor, and it's a craving for a bit of detail for the sort of thing that can be investigated within 30 days and responded to within 30 days, which the other provisions of RESPA require. If the court has no further questions, I respectfully ask the court to affirm.
Very good. Thank you very much. Mr. Robinson?
Yes, Your Honor. In pointing out to Ms. Johnson, my friend claims that her letter had nothing to do with payments. The second paragraph, last line of her letter at JA 129 says, I was previously approved and I have made and continue to make each trial payment in reliance to your representations to me.
But counsel, that's not, so that's I think misrepresenting the argument. The question is not whether the letter regarded payments, but the argument is the statute and the regulation prohibit furnishing adverse information to a reporting agency regarding a payment, right? And so if they just report the loan balance, I take his argument to be that if you just report the loan balance, that is not information regarding any payment.
Your Honor, I'm referring to Ms. Johnson's QWR. I think the credit report that you're discussing is Mr. Morgan.
I'm reading the statute.
Right. So the credit reporting suppression provision is if there is a QWR received and there's no dispute and based on the well-pled facts that Caliber treated both correspondents as QWR notices of error. That's at, they received it and they responded to it. That's paragraph 67, JA 19 and 20 as to Ms. Johnson. They treated Mr. Morgan's as a QWR NOE. That's paragraph 36 and 13. Once they treat it, and to Your Honor's question about statement of reasons, the case law.
No, I'm sorry. I thought you were getting to my question. I'm still going back to the question that I was asking you, which is the credit reporting agency provision is limited to Caliber providing information regarding any payment. And what I was asking you is, what payment are you alleging for Ms. Johnson what payment was provided to the credit reporting agency?
Right, they provided, it's pled in the complaint that they received her letter and within there's specific paragraphs identifying for her and Mr. Morgan that they provided to each of the credit bureaus derogatory information. So the underlying merits.
But what you don't allege, this is what I'm getting at, right? With Ms. Johnson, do you allege that the derogatory information was, quote, regarding any payment?
The derogatory information that was reported was regarding her payments, and that's described in her letter where she specifically asked them, Your Honor, to suppress that. She didn't have to under the statute, but she did from October 18 to a period of 60 days after they completed the response. That's on JA 130. The denial that's Exhibit 1, JA 131, I would point out for Ms. Johnson also, informed her of the right in response to the denial to submit a notice of error request or information, which is exactly what she did, as well as appeal. Caliber treated both correspondents as QWR NOEs. Both correspondents provided a statement of reasons. It's true that Mr. Morgan's is not written by a lawyer. I don't think the standard under RESPA, the remedial statute that's been broadly interpreted by the sister circuits, is that you don't need to be precise here. There's no exacting nature on consumers.
Do you agree that you have to provide some reasons, right?
Right.
A statement of reasons has to include some reasons, right? Which means some why. You have to answer the why question, at least at some level, like I owe nothing, or I owe 16,000, or I owe 30,000, or I owe, but some why there's an error, right?
Right. I don't disagree with Your Honor that there needs to be some explanation of what the statement of reasons are. I disagree with counsel's contention that the federal pleading standards apply to these letters. Mr. Morgan provided the why. He provided information, and I don't think he has to write this out in the letter because it's contained within the attachment as well, the various amounts that were claimed due.
No, but the point is, it's a statement. I mean, you agree, a statement is something that is, it has to be written, and it has to be a statement. So a statement is something that's written out, right? It's not a like, puzzle, right? So it's a statement of reasons, right? So a statement of why.
Right, and what I'm suggesting, Your Honor, is I don't think it has to be, in this case, it could be attachments like it was with Mr. Morgan, with the credit report showing both Bank of America showing the loan with a zero balance, then Caliber showing it with a different balance, and the representative, Thomas, identifying a third balance, plus hundreds of dollars in late fees. So I think collectively, in a light most favorable to Mr. Morgan and the inferences therefrom, that qualifies as a statement. The servicer, and I'm going to run out of time here, but if I can just finish answering the question, these claims arise out of the servicer's duty to perform a reasonable investigation, similar to what this court found previously under the Fair Credit Reporting Act. The servicer has access to the mortgage note that would tell it that this loan's term expired years before this correspondence was received. The servicer has that information, and if it has enough information to look up the account, it can see, and then it has to perform a reasonable investigation and explain back to Mr. Morgan and to Ms. Johnson what the errors were. And we see, and with Ms. Johnson's example, they did respond back, and they acknowledged the error and they made the correction after treating her correspondence as a QWR NOE. So we think under the circumstances, both letters should qualify. Caliber did not make this argument that they weren't QWRs, NOEs until it was sued. It treated them as such before it was sued. The district court erred in finding both correspondents don't qualify under the statute and the regulations, and we'd ask the court to reverse the ruling below. Thank you very much, and I'll rest on the rest of the brief.
Thank you, Mr. Robinson. We appreciate it. We'll let this case for consideration and resolve it promptly, we hope. Madam Clerk, we'll adjourn court until 9:30 tomorrow morning, and then the court will confer.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.